Welcome again, everyone. We're back here for the second day of oral arguments on the Holtec matter. Holtec International's application to construct and operate an interim nuclear waste facility in Lee County, New Mexico. I think the way we'll proceed this morning is first with fasting, and then I believe if the representative of the city of Carlsbad is here, we'll give you a few minutes to say what you'd like to say, and then we will turn to Holtec, which will probably take quite a bit more time, and finally the NRC staff. Any questions about how we're proceeding today that we haven't addressed? Everybody's prepared to go forward? Good. Somebody, yes. And a reminder again to turn off or rather silence your cell phones will help a lot. Okay, well let's begin then with the representative of fasting, Mr. I.
May it please the panel, my name is Robert I. I represent Fasken and Permian Basin land royalty owners. At a bare minimum, any decision concerning the establishment of a consolidated interim storage facility that would have the greatest concentration of radiation between here and the sun should be done in conformance with applicable law. The application before you now does not meet this minimum test. Including any Department of Energy involvement in this proposal violates the Nuclear Waste Policy Act. When Congress passed the NWPA, it recognized the real possibility that establishing a CISF without a deep geologic repository would effectively relieve the pressure off the imperative to establish a deep geologic repository. Why did Congress and the NWPA require the repository be available and operational before allowing a CISF? Congress well recognized that putting a CISF into operation simply allowed a further delay in establishing a deep repository, kicking the can down the road farther. And yet, in 2019, there seems to be a doubt about whether this unambiguous intent of Congress that clearly is manifested in the text of the NWPA is being met by the application presented by Holtec. This doubt raises all the familiar problems with reaching a final disposition of spent nuclear fuel in a deep geologic repository. As plans are made to store 173,000 metric tons of spent nuclear fuel in southeast New Mexico, durations of time for the use of this facility exceed 100 years. What is the public to make of this? Hearing these durations with no prospect of a deep geologic repository raises the issue of adherence to the rule specified in the NWPA. The applicant and staff have been silent about this attempted end run around the NWPA. This silence, coupled with the idea that the proposed CISF will be in operation for over 100 years, leads to the conclusion that a deep geologic repository is just so much pie in the sky. The authors of the NWPA would be troubled and perplexed by this circumstance. They would be, I think, very disagreeable about how their careful sequencing and balancing in the NWPA has been disregarded in the Holtec application. This application puts the cart before the horse. In doing so, the NWPA is violated. And that is why Fasken and PBLRO took the steps it did to file a motion to dismiss the application. And I'm sure that there will be, I sense that there may be some questions about that later, so I will turn and make a few brief statements about standing. Fasken and PBLRO have standing. First, as discussed in the declaration of Tommy Taylor from Fasken, Fasken has mineral interests 2 miles from the Holtec site. These are mineral interests that represent a substantial business investment, and they want to protect those. This close proximity puts Fasken well within the zone of the 14 to 17 miles that we've discussed, that we've heard discussed prior, that has been recognized as a proximate distance to justify standing in a CISF context. Fasken's interests and their interests of their counterparts in PBLRO are jeopardized by the Holtec proposal for its CISF. Not only are the economic interests related to the mineral rights at stake, but as Mr. Taylor points out in his declaration, there are concerns about the health and safety of people in the area who are exposed to this radiation. And that indeed, that might force Fasken to incur further costs to accommodate a CISF. Fasken and other members of PBLRO work and live in that area. And Fasken, for example, has to dispatch workers out to that area to tend its interests. Fasken recognizes that things like medical costs, lost productivity, and long-term viability of their business interests are directly at stake with the CISF as proposed in this matter. You heard yesterday about how the oil and gas industry is so robust in the Permian Basin area that they can't find enough workers to fill all the available positions. This is a sign of business activity that's not only enviable, but it helps sustain the economy of this area. The thousands of jobs that Fasken and its PBLRO counterparts offer are at stake, which ripples through the way of life of this entire area. PBLRO's purpose, as stated in our papers, is to protect those interests from the hazards represented by the Holtec CISF. Accordingly, PBLRO has representative standing. With that, I will do my best to answer any questions that you have.
Thank you, Mr. Rye. I think we put in our January 10 order 2 questions that really are directed at you, questions 3 and 4. Let's assume that your clients have standing. Hypothetically, let's assume the board concluded that. The issue that we see is, and it's complicated by the procedural posture here. Let me go back a little bit. You, on behalf of your clients, filed a motion to dismiss, as I recall, not a petition with contentions. And Beyond Nuclear filed both a motion to dismiss and a protected matter petition with one contention, fundamentally the same issue as the motion to dismiss. Your motion was directed at the commission. Through the secretary, the commission has in effect said that we should treat your motion as a petition with a contention. The problem that I see, I think the board has concerns about, is that commission case law is pretty clear that a petitioner may adopt the contention of another petitioner, but only if the petitioner who wants to do the adopting has a contention of its own. And in this instance, your motion essentially adopts the arguments presented by Beyond Nuclear's motion. And so therefore, aren't we kind of stuck with the rule that you have not submitted a contention of your own?
As we explained in our response, that I think addressed this, at least in part, it was never our intention to present a contention. I mean, to us, this is a counterpart, a parallel. It's analogous to a Federal Rule Civil Procedure 12B motion. It says, in effect, that the commission lacks jurisdiction. That's a classic 12B motion. If we concede that a petition, or that a contention is necessary, we effectively have abandoned this idea that somehow that you have jurisdiction, that you don't have jurisdiction. We implicitly say, with this contention, you have jurisdiction to decide this case. And indeed, it goes to the heart of our arguments that the issue of the NWPA's involvement in this case, although absent from the discussion from the applicant staff, is one that is extant and it's existential in this case. A jurisdictional matter ought to be handled properly in the context of a motion to dismiss. I grant you that it falls outside the strict formalities of contention practice, but so does the omission of discussions of the NWPA. So how do we respond to that? Do we essentially accede to the idea that the commission has jurisdiction, submit a contention, and let it play out, only then to be confronted by a judge on appeal who says, it appears to us that in fact you recognize the NRC's jurisdiction over this? So we were caught, one of the other counsel put it well yesterday, caught between the proverbial rock and hard place. The context of this is unusual. It's unusual for the panel, for the commission, for the participants. And we couldn't find another instance. We looked. We couldn't find another instance where the secretary had actually taken the step that was taken here, where they take a pleading, they send it back to the panel, and they say, treat it in this way. So that lack of precedent puts us all into unknown territory, I suppose, or uncharted territory to a certain extent. But we have to remember that the essential piece of this is to ask, has the applicant conformed to the Nuclear Waste Policy Act? Irrespective of the procedural means to get to that question, whether it's through a contention, whether it's through a motion to dismiss, the issue remains the same. So we certainly were not intentionally setting out to make this thing a procedural morass. We really were not. On the other hand, we had to make some judgment calls about how to proceed, and this seemed like a logical way to proceed, to have it run more or less like a 12B motion would in civil practice in court.
Beyond Nuclear's response to the Secretary's ruling was also to go directly to a federal court of appeals. In Beyond Nuclear's case, the United States Court of Appeals for the District of Columbia Circuit. Have you sought relief in the Court of Appeals on an interlocutory basis? Or have you sought relief in the Court of Appeals? Have you sought to review the SECI's order in the Court of Appeals?
We have not yet.
Okay. is your time, do you still have time to do that?
We have not. We're here. And again, this is a, frankly, this is a procedural scenario that only Franz Kafka could really completely appreciate. And it does leave us all a little uncertain about what steps ought to be taken. So, partly respecting the fact that the Secretary sent our motion back to the panel and asked that it be characterized and considered as a contention. In respect of that, and to have an opportunity to present our arguments to you, we hope in a persuasive fashion, we decided to pursue this route at this point. And again, it is unusual. We're hoping that at some point procedurally we get clarification, but I'm not actually counting on that. So,
okay, I think if I understand your argument correctly, I think I do better as a result of your comments right now. If you had filed a petition with one contention that adopted somebody else's contention, it is pretty clear, I think, under commission precedent that you are out, that you can't just adopt somebody else's contention. You have to have one of your own. But what you're saying is, I think, is that this is a very unusual, indeed unique situation where we, that is the board, has been told to treat this as a contention, but this is unprecedented, and perhaps the commission's ruling on that issue was intended to apply to people who had intentionally filed contentions, but not to those who were told you may have filed a motion, but it is a contention, it's going to be treated as a contention. So we should consider it in that light.
Perhaps. I mean, but there are other ways to interpret what was done as well. So again, we're working in sort of an unclarified context.
Yeah, but I mean, what you're saying, I think, is that we should consider whether the commission precedent applies in this unique situation. The commission precedent in the normal situation is, I think, pretty clear. But you are urging that we take a hard look at whether the commission precedent, which would effectively throw you out, your client out, whether the commission would really have intended it for it to apply in this unique situation.
That is correct, Your Honor. And one other minor, I think relatively minor point here. I'm not sure that I really agree that we have adopted the contention of Beyond Nuclear. We adopted their legal argument because they happen to support our client's interests. The contentions have certainly the same intention, rely upon the same legal reasoning, but they're different parties with different interests. So I don't really think that point is controlling. I don't think it's dispositive. I think what's dispositive is what you just articulated, Judge, in terms of trying to figure out what to do in this unusual context where you have neither fish nor fowl. And yes, that is unusual. The NRC's general practice for resolving these kinds of disputes is through contentions. So all of a sudden now you get a party who throws a curveball and raises a motion to dismiss. It's not as if motions to dismiss are unusual or unheard of in various forms of practice. It's just that in this context, it's outside of what is normally expected.
Okay. Thank you. Judge Horn?
No questions.
Judge Clark? No questions. Thank you.
Thank you.
Well, let's deal with a few brief comments from the city of Carlsbad. Is that Mr. Shirley? Welcome, Mr. Shirley.
Thank you, Your Honor. I appreciate the opportunity to speak to you today, and I apologize, my voice is a little rough today, so we're going to get through this stuff. As you know, my name is Jason Shirley. I serve on the City Council in Carlsbad, and I'm the designated representative to the Eddie Lee Energy Alliance that is working with Holtec on this project. Carlsbad has an official population of 27,000 people, but is much larger in recent years due to the expansion of the oil and gas in the region. Excuse me. Additionally, Carlsbad is approximately 35 miles away from the proposed Holtec high-store consolidated interim storage facility. Carlsbad has been keenly interested in the development of the Holtec site since the 2013 report from the President's Blue Ribbon Commission recommendation that a consolidated interim storage facility be established. The CISF will have a real impact on our community, and we expect that it'll bring the following benefits to Carlsbad, that it'll create several hundred jobs for our citizens, that those jobs will come with high salaries and raise local wage averages. It'll generate significant tax revenue for the city of Carlsbad, improving our infrastructure and further diversifying our economy. It will not only benefit our region, but also provide a service for our nation in safely storing spent nuclear fuel. We're familiar with living near a site for nuclear waste disposal, as we are located 25 miles from the existing waste isolation pilot plant facility that's ran by the Department of Energy, which employs some 1,200 people and has a $400 million annual budget that benefits the region very greatly. Our constituents support the Holtec CISF. We know that we are a nuclear savvy community with many years of experience in the field. We've seen success, we follow the science, and we have a culture of safety in Carlsbad. We also are here today to show our support for the Holtec CISF. It's welcome in our community. We look forward to the jobs, the revenue, the diversification, and the other benefits that it will create. Thank you so much for your time today.
Thank you, Mr. Charlie.
Yes, sir.
And I'd just like to confirm, I believe we heard yesterday that the city of Hobbs will not be participating orally. Again, all of the petitions by local governments stand unopposed at this point, so there's certainly no need to say anything today. We will next move to Holtec, and just two comments to start. I don't know, Mr. Silberg, will you be speaking?
I will be making
the opening statement. I don't know if you need extra time. We recognize it's 5.5 to 1 at this point, perhaps, is the way to characterize it. So our clocks might run a little slow on the 10 minutes if you need more time, but you may conclude that you really just want to answer the questions. Either, Mr. Silberg, you or one of your colleagues probably should address at the outset, either as part of your opening or right after it, the issue we asked for some comments on yesterday. And what that related to was NAC's argument that if they are not in this proceeding to address the environmental report issues now, they will not have the same opportunity at a later time. If there's an amendment, hypothetically, that would permit the NAC canisters to be placed in the Holtec casks. So either you, Mr. Silver, could address that in addition to your general opening, or one of your colleagues would appreciate that. Thank you.
Good morning, Mr. Chairman and members of the board. Holtec International appreciates this opportunity to appear before you as an important step forward towards the licensing of the Holtec high-store consolidated interim storage facility. We believe that this is an extremely important facility for this nation. Holtec is pleased to be able to sponsor it. We're disappointed that we need it because the Nuclear Waste Policy Act provided that the Department of Energy was supposed to start accepting spent nuclear fuel from the nuclear industry starting January 31, 1998, a day some of us will say will live in infamy. Because they have not met that obligation, and because we do not have a permanent repository, Facilities like this are necessary for a variety of reasons. There are stranded spent fuel storage installations around the country. There will be more of them as time moves on, because plants are shut down, the plants are decommissioned, and everything but the spent fuel is off the site. Facilities like the Holtec facility will enable those sites to be finally returned to other productive uses. Both the utilities that own those sites and the jurisdictions in which those sites are located would desperately like that spent fuel to be stored safely, environmentally secure at another location. This location is also a much more secure location than where many of the interim spent fuel storage sites are now located. Some of those are very near major metropolitan areas. There are many of them scattered around the country. It is safe at those locations. We believe it is safe. The Commission has found it is safe. But it would be better if it were in a more remote location, far away from metropolitan areas. In any event, with those introductory remotes, let me first introduce the Holtec team. Our attorneys from Hillsburg Law Firm in Washington, myself, Jay Silberg, Tim Walsh, and Ann Lighting, my associates. The Holtec management, project, and technical personnel here today: Joy Russell, who is the Senior Vice President and a member of Holtec's Executive Committee; Ed Mayer, who is our project director for the iStore facility; and Kim Manzione, who is the licensing manager. Let me give you a little bit of background about Holtec. The company was formed in the mid-1980s. Today it designs, engineers, licenses, manufactures, and deploys its technology and services around the world. And while nuclear is the focus of Holtec, Holtec also provides technology for solar, geothermal, and fossil power industries. Holtec's early focus was on heat exchanger technology, and today over 120 power plants on 4 continents use these Holtec components. In 1992, Holtec launched its technology for dry storage of spent nuclear fuel. Among the first of that technology were the first licensed multi-purpose canister storage and transportation, the first dual-purpose metal cask, the first transport cask licensed for high burnup and MOX mixed oxide fuel, and the first double-wall canister for spent fuel storage. The Nuclear Regulatory Commission has issued certificates of compliance under 10 CFR Part 72 for 4 different Holtec dry storage technologies. Its dry storage systems were first installed in 2000, and today over 1,200 Holtec systems are in service, storing more than 62,000 spent fuel assemblies in 65 nuclear sites in the U.S. and 51 nuclear sites abroad. In addition to dry storage, Holtec is a leader in wet storage technology and is currently developing the design for a small modular nuclear reactor. And more recently, Holtec has become involved in the nuclear plant decommissioning and has agreements with 2 utilities to own and decommission their reactors, including assuming the ownership of spent fuel. The NRC staff is now reviewing the license transfer applications for those facilities. Once those transactions close, Holtec will, in essence, become a nuclear utility owning spent fuel currently on dry storage and cool storage. Holtec manufactures all of its own equipment and has 3 U.S. manufacturing facilities with more than 1,400,000 square feet of manufacturing space. In addition to manufacturing dry storage systems, Holtec is also constructed spent fuel storage facilities, and provides for moving spent fuel from pools to pads. A little bit about the project. I think as you've heard from representatives of the jurisdictions that will host the facility and that we work with closely, Holtec has a well of local support for these facilities and a well of support around the state. In 2015, the governor of New Mexico wrote to the Secretary of Energy suggesting the consideration of an interim storage site in southeastern New Mexico. In 2016, the House and Senate of the New Mexico legislature both issued memorials in support of a CISF facility. In April 2016, the Eddie Lee Energy Alliance, that you've heard John Heaton speak about yesterday, in the cities of Carlsbad and Hawes, and Holtec entered into a memorandum of agreement for the high store facility. And in July of 2016, the New Mexico Board of Finance approved an option agreement for the sale of the high store site to Holtec. As you've heard, the site is in Lee County, about 35 miles from Hobbs, and about 35 miles east of Carlsbad. It's a little bit over 1,000 acres. The area is home to other nuclear projects, as you've heard, the Urenco Uranium Enrichment Facility in Lee County, and the DOE WIP facility in Eddy County. The project itself will use Holtec canisters, the initial phase, with NRC certificates of compliance that are loaded and welded shut at utilities, transported to the site unopened, and placed in subsurface vertical modules at the site. The canisters are not opened after being welded shut at the utility site. The initial phase will be, for which we've applied, is 8,680 metric tons or 500 casks. And the initial phase is limited to Holtec casks and canisters. There may be subsequent phases. The site is capable of storing 100,000 metric tons of uranium in 10,000 canisters, though Holtec is not asking for a license beyond phase one. But because expansion is possible, the environmental report evaluates the environmental impacts for all phases. And I would notice there has been a lot of discussion that the capacity is 173,000 metric tons of uranium. That is a number that is not correct. The capacity as defined by Holtec is 100,000 metric tons. Studies at the site started in 2006 as part of the Global Nuclear Energy Partnership, a $250 million DOE project to develop advanced nuclear technologies. iStore is based on licensed technology which is currently installed and in operation. The High Storm UMAX, the underground storage, certificate of compliance was issued in 2015 and is currently in use at 2 U.S. nuclear plants. I want to be very clear because a lot of the discussion centers around the role of DOE. This project is not dependent on contracts with DOE and is not dependent on DOE ownership of the spent fuel. I'm happy to respond to the questions you may have on that. But the short answer is, if DOE is not entitled to hold title to commercial fuel, DOE won't be involved. The NRC review, the application was filed in March of 2017. It was accepted for NRC review in March 2018. Holtec has received 4 requests for additional information from the NRC staff. That process is well underway. As to the petitions to intervene, we've carefully examined each one and have addressed in our submittals whether each has met the Commission's requirements for standing and contention admissibility. And we believe they have failed to meet those requirements. Our answers to the petitions set forth our position in detail and explain why the petitions do not meet the NRC standards. In the interest of time, we will not try to summarize our positions, for they are well set forth in our brief, but we're very pleased to answer questions that the board may have. We thank the board for being here. We look forward to answering your questions, and we look forward to dealing with you through the completion of this licensing facility. I'd like also to ask the board's permission if we could sit at the front row. We'll be passing the microphone, and if we could have the microphone back and forth between Tim and Ann and myself.
Yeah, I think that would work nicely.
Thank you very much.
Our space here was not what we originally intended, and we're doing the best we can.
We understand. Let me first address the question you raised about the NAC issue. We believe that it's incorrect that if they're not in this proceeding, they will lack the opportunity to address the environmental report. Right now, the application does not permit the storage of NAC casks or non-Holtec casks at this facility. We accept and have been very clear that in order for other vendors' casks to be stored at the site, we would need to amend the license and would need to amend the certificate of compliance for the UMAX system. Because right now that is only licensed for Holtec casks. It may well, we may well file those applications. The casks, the underground facility, are large enough to accommodate casks of any canisters of any manufacturer. That's why we call it universal. We recognize that NRC will have questions. We recognize that the licenses and the certificate of compliance may need to be amended. At those times, we will have to, as part of the application, determine whether there are any changes needed to the environmental documents that have already been submitted. There will be an environmental statement in each application. That statement may be, no change is required. If a change is required, our application will include that. If the NRC staff disagrees with our conclusion, if that is our conclusion, that no changes to the environmental analysis are needed, the NRC can ask us additional questions or can provide that information on their own. We will have to deal with it. If NAC believes that our conclusion, if that is our conclusion, that no changes to the environmental report are needed, they can challenge that conclusion in the appropriate forum, which may be a license amendment, may be an amendment to the COC. They will have rights to participate. They will not be shut out. Right now, their interests are not affected because they're not in the application. We don't say in the environmental report that any NAC casks will be stored at the site. We've tried to bound the environmental impacts by saying, here are the impacts for a fully developed site. If the site is less than fully developed, if we only build 5 phases instead of 10 phases, we have bounded the environmental impacts. If we reach the full capacity of the site, we will have fully addressed the environmental impacts. But in no case are we shutting out NAC if they have issues with their particular casks. But what we have looked at here is the capacity of the site, whether it's 100,000 tons in Holtec casks or 100,000 tons in Walmart casks. Whose ever casks those are, we have evaluated. There's nothing unique about NAC. Their interests are not affected. We're not saying anything good, bad, or different about their technology. So our answer is, we don't think they need to be in this proceeding to protect their interests. We don't believe they have demonstrated that they have standing, and we don't believe they have demonstrated an admissible contention.
Thank you, Mr. Silver.
And at this time, if I could regain my seat, and we'll go through.
You may. It could be a long time at the podium otherwise. I probably have fewer questions in my technical colleagues, so let me begin again. First, Mr. Silver, you have every right not to respond on this points. There were last week motions to file new or amended contentions that seem to be pretty closely related to Beyond Nuclear Contention 1 and Beyond Nuclear's own contention and Sierra Club Contention 1. And are you prepared to discuss those at all now, or do you want to wait? You have until, I think, mid-February, February 11th, something like that, to respond to those.
I can certainly discuss it.
Okay.
I can certainly do.
That works.
I missed my career as a rock singer. I can certainly discuss them, and I think I would like to put in perspective some of those statements that have been made, because I think for those who may not be familiar with the project, there is a lot of misinformation that we've heard.
Excuse me. Yeah, I mean, if you're prepared to address them, then to some extent, you have time to respond in writing, and then there will be a reply. But I must say, I was somewhat struck myself by what appears to be a Holtec document that was issued this month. And we hear from you that if DOE can't be involved, they won't be involved. But the Holtec document, I'm not quoting it, but loosely says, and of course, this Lee County project will have to await action either by the Congress or by DOE. And that was confusing to me.
Let me read you the sentence, and I would say that this is one sentence out of a 6 or 7 page document. The sentence has been totally taken out of context by the interveners. What the sentence says is, quote, "Why we endeavor to create a national monitored retrievable storage location for aggregating used nuclear fuel at reactor sites across the United States into one, high store CISF, close to maximize safety and security. Its deployment will ultimately depend on the DOE and the U.S. Congress." And it's that last phrase that seems to have gathered everybody's attention. Honestly, I think the sentence has been totally misconstrued by the petitioners. The phrase in question, "its deployment will ultimately depend on the DOE and the U.S. Congress," does not say that we need DOE approval to go ahead. It does not say we need DOE to hold title to spent fuel. It does not say we need DOE to take over any aspect of this project. What it says is that if DOE and the Congress make decisions, particularly with spent fuel storage and permanent storage, that will have an impact on this project, and its deployment will depend on that. If, for instance, Congress and DOE decide to go ahead with Yucca Mountain, we pray that would happen. And it's ironic that people who criticize this facility as perhaps reducing the incentive for permanent disposal are among those who have fought toughest to keep us from developing Yucca Mountain. Putting that aside, if Congress were to take steps to put in place permanent disposal or federal interim storage on a schedule that made the CISF, the Holtec High Store project, unnecessary, obviously that would have an impact on the Holtec High Store project. So its deployment would ultimately depend on what DOE and Congress does. If we build phases 1, 2, 3, 4, 5, and Yucca Mountain becomes available, we won't build phases 6, 7, 8, 9, and 10. So the obvious connection between the state of the DOE nuclear waste program and interim storage is clear to everybody. Because if we had interim storage in operation today, we wouldn't be here. We would be most pleased to be sending fuel directly to Yucca Mountain. Unfortunately, we're not in that position. utilities, after having contributed $35 billion to the federal treasury to pay for Yucca Mountain, find that their money has dissipated. $7 billion has been spent on Yucca Mountain, and there are people in Congress and in the outside community who would like that money to be thrown away, for Yucca Mountain to disappear forever. If Yucca Mountain proceeds on a schedule which makes this facility unnecessary in whole or in part, if some other permanent disposal facility were developed on a schedule which makes this facility not usable in whole or in part, that would have an effect on the deployment of this facility. That's what that statement means. Nothing more, nothing less. The environmental report has been amended. Rev 3, which was filed with the NRC in November, which is available, publicly available, has made clear that a few references in the report where it appeared that DOE would hold title to the fuel or would be responsible for the fuel that would come to Holtec. Those references have been clarified to make sure that it's either the utilities or DOE. And the reason DOE is in there is DOE may have the ability to take title. They don't now, we agree with that, for commercial fuel that they don't already have, unless it's through an R&D program, because DOE has a few assemblies from commercial reactors that it took for R&D that are currently at Idaho National Labs. But if Congress passes legislation that allows DOE to take title, if Congress passes legislation which authorizes direct funding for this project, then sure, DOE would have a role. That isn't the situation now. We're not depending on it. We don't assume it. The statement that we heard yesterday that having option 1 and option 2 means that both options are illegal just makes no sense at all. Severability clauses exist throughout private and contracts and public statutes. There's no indication that putting DOE as a possible participant in this would make illegal private participation in the absence of DOE ability. The environmental report where these statements appear is to describe what are the environmental impacts. If you look at it in that context, we don't need to address who owns the fuel at all, because whether it's DOE holds title, or the utilities hold title, or Holtec holds title, the environmental impacts are going to be identical. So the statements in the environmental report are useful for background information, but in terms of environmental impacts, and that is what the environmental report is there to do, those statements have no bearing and don't provide a basis for contention in this proceeding.
I just want to be sure I heard you correctly, Mr. Silver. You said that today, are you conceding that as of today, DOE cannot take title to spent nuclear fuel, that it doesn't already own? Cannot take the power company's spent nuclear fuel, take title to it today, as the law currently stands?
I agree with you in general. I would note that DOE has taken the position that it has authority under the Atomic Energy Act, under its Research and Development Authority, to take spent fuel to study, and they have done that. The DOE has the core from the 3 Mile Island Unit 2 facility sitting up in Idaho. They studied. They have occasional assemblies. I believe they have one from North Anna. I think they may have one from Point Beach that has been moved to Idaho and is being studied. The high burn-up fuel program that's being developed already in effect, that's a DOE EPRI program. DOE is going to take fuel, I believe, from North Anna in a cask. Eventually that cask will be moved up Idaho. They'll open it and confirm that high burn-up fuel it is not being destroyed because it's high burn-up fuel. So there are cases where DOE has title, but what we're talking about, and those are very, very small quantities compared to the amounts that we're talking about. And that's not the focus of this project. But I would agree with you that under current legislation, DOE cannot take title to spend nuclear fuel from commercial nuclear power plants, under the current statement of facts. But that could change depending on what Congress does.
Yes, it could change based on what Congress does. But I guess where I was coming was I was going to suggest that this seemed to me like an ideal issue for a legal issue contention. We did not in the pleadings have your position on the lawfulness of DOE's taking title. And we didn't have the staffs, which I think treated that issue as premature.
But the reason we didn't put the legal position in is because it's irrelevant. Because we don't depend on DOE's taking title. And we say we don't depend on DOE's taking title.
But for option one, you do, don't you? Wouldn't you?
If that were the case. But option one, as we
Okay,
talked
so in
about,
other words, option one is a contingent option based upon something happening
in the
that
future.
makes it lawful. Okay.
Correct.
So we don't need to argue whether it's lawful today. You
I
agree?
don't think there's any dispute on the law as to DOE's current authority to take title for other than R&D purposes.
Okay, other than what you characterize, I think, as a narrow research exception.
Correct.
You agree, Holtec International agrees that under the Nuclear Waste Policy Act, today, the DOE may not lawfully take title to spent nuclear fuel.
Correct.
Correct. And the staff, I just have to turn to the staff on this, which consider the issue premature. Does the staff agree with that?
Does the staff agree that it's premature, or does the staff agree that it's unlawful?
I'm sorry.
I just want to make sure I'm answering the right question. Are you asking if the staff agrees that it's premature?
No.
Or if the staff agrees that it's unlawful?
No, you've said it's premature.
Okay.
You said it was premature. My question today, having heard Mr. Silberg's statement on behalf of Holtec International, does the staff agree that as of today, it was unlawful under the Nuclear Waste Policy Act for DOE to take title, put aside the research exception, to generally take title to spent nuclear fuel?
The staff has not reached a position on that issue at this time.
All right. Well, we have Holtec's position. We may find that satisfactory. I don't think we probably could. Well, we'll probably have a few minutes for everybody at the end if we have time, and we can see. But it seems to me that what I thought appeared to be just a fine legal issue contention is no longer necessary.
I think we're all in violent agreement on this question, except perhaps with the staff.
All right. Well,
But I will note that in the litigation that arose out of the DOE breach of contract, we argued, going back to the 1990s, that DOE did have authority, other than the Nuclear Waste Policy Act, to take our spent fuel, as they were taking it from foreign research reactors, for instance, or 3 Mile Island. And DOE and the courts, DOE argued that that was a unique Atomic Energy Act R&D authority, and the court generally agreed. We've conceded that since then.
thank you. Okay, well, let me move. I have really just a few more questions, and then maybe we'll take a break after those and go to my technical colleagues. But on Sierra Club Contention 4, this is the challenge to primarily a challenge to the consequences of an accident, a transportation accident, with respect to spent nuclear fuel. The Sierra Club, I believe, relies upon the Lamb and Resnikoff study based on the 2001 Baltimore tunnel fire, and treating that as though it had been a nuclear accident and the consequences of that. And the Sierra Club's position is that at the very least that raises a factual dispute for which there should be a hearing. And your position, as I understand it, is that you have cited the 2008 final supplemental environmental impact statement from the Department of Energy on the Yucca Mountain case, which was rather critical of that study, and which would be grounds for, I think, at the least, you would argue, at the least saying that that is the Lamb and Resnikoff analysis represents a worst case basis, which the applicant's environmental report does not need to deal with. And my question for you, Mr. Silberg, is that apparent from the environmental report? Or I know the commission has said that it is the applicant's job to read, not the applicant's job, the petitioner's job to read the application, read and study the application. But this is a citation in the application. Does the application explain that position explicitly, or would the petitioner be required to read the application and then read every citation of the application?
So before we do that, and my colleagues are looking to see exactly what it says, let me make a number of other points.
Okay.
First of all, we don't think that the Lamb-Resnikoff study is material in this case for a number of reasons. One is there's no showing that tunnel is on a rail route that will take fuel from anywhere to CIS. Second, the larger criticism in the Lamb-Resnikoff study is that the fire that engulfed the train in the tunnel was more severe than NRC requirements require. I believe is 1,800 degrees maximum temperature. The NRC Part 71 standards for transportation casks give a maximum temperature number that is below that. I believe it's 1,400 degrees Fahrenheit. So in essence, that's a challenge to the NRC regulations for designing casks. If they wanted to put in a claim for a waiver of the NRC Part 71 standards, they could have done that. In fact, the Part 71 standards are should not be involved in this case. The transportation casks that Holtec would use have their certificates of compliance. You don't challenge in this case, in a licensing case for a site-specific license, a certificate of compliance that's been adopted by the Commission in a rulemaking. If they wanted to challenge that, they're well beyond the time frame. The Lamb-Resnikoff study is also inapplicable to this case because the reason that tunnel fire was so intense were the contents of the cars. Holtec will ship spent fuel by dedicated trains. There will be no contents that will be flammable of the type that created that fire in the tunnel. So that study, while it's interesting, and that was a very significant fire, has no relevance to spent fuel transportation. And further, as we explained, there are requirements that the Federal Railway Administration review all the routes to make sure they are appropriate. We believe that if the Baltimore Tunnel were on a transportation route to the high store facility, that the FRA would review that route, and if in their expert judgment they determined that it was an inappropriate route, we would bypass it. If they determined it was an appropriate route and we needed to use it, we would feel free to use it. So for all those reasons, I think Lamb-Resnikoff is of no relevance in this case. It challenges the NRC regulation. I don't know. I'll pass the mic to Walt.
Thank you, Your Honor. With respect to your question about if the environmental impact statement addresses this, section 4.9.3.2, accident impacts, discusses how the Holtec analysis was tiered off of the Department of Energy final environmental impact statement. So the explicit reference is there. And while the ER doesn't specifically address the Lamb-Resnikoff report, that's what the analysis is based on. And the DOE analysis specifically addressed the higher estimates provided by Lamb-Resnikoff.
Okay. But Sierra Club's counsel, if he read the application and the environmental report, he would have seen the citation, but he would not have been clued in any way that the Lamb-Resnikoff suffered from the deficiencies that the supplemental environmental impact statement addresses.
Certainly, Sierra Club's expert, Dr. Resnikoff, would be intensely familiar with the criticism that's
Good point, sir.
levied against it.
Okay, thank you. But, okay. Couple more questions. Sierra Club Contention 8. And this is a contention that I believe the NRC staff says is admissible, at least in part. The calculation of the annual contribution to a fund for looking for the right word, for closing out the facility, decommissioning the facility. Holtec, I think the staff's principle, I believe Sierra Club saw an inconsistency between the numbers that were in perhaps the environmental report and in other parts of the application. And the staff raised the issue of, well, whether can we assume that every canister is full? It may vary in the amounts. And so from both those directions, there was some challenge to whether there isn't an admissible contention on whether the amount, the metric tons of uranium at a certain amount would give rise to the total decommissioning fund payment that you calculated. What is your response on that?
As explained in our response, Your Honor, they used the wrong number, and so we detailed in our response their contention that it was...
Excuse me, they would be the Sierra Club.
Yes, Your Honor, Sierra Club. They used the wrong number in their calculation, and we laid out the calculation for them in our response, and also they overlooked the fact that the real rate of return, which was discussed...
Yeah, that we understand. The real rate of return they ignored. But there were two numbers in the application.
Let me just say, the environmental report clearly says 5,000 metric tons, and you used a capacity of 8,600 and something metric tons times the $840 per metric ton. So that confusion still exists.
I am confirming that the correct number was used in the decommissioning funding plan, but let me, if you give me a moment, I can check.
While Tim is looking, let me make one further point in terms of the staff's, and I don't want to put words in their mouth, but the staff's response to the contention and finding of admissibility was made before it had the benefit of reviewing our response to the contention. I don't know whether the staff would be in a position to say that cleared it up for them or not, but they did not have the benefit of that when they filed their contention response.
Well, while we're waiting, we might as well ask the staff. Thus far, the staff has not changed its position on anything, but let's ask whether the staff's review of Holtec's response has affected the staff's position. In other words, the simple question, I should try to simplify it, is that does the staff continue to assert that the Sierra Club Contention 8 is either admissible or you would not oppose its admission?
Your Honor, at this point, the staff would like to change its position to take no position on the admissibility of that contention.
The staff is taking note of the position. Are you changing? You're changing your position to no longer oppose? I mean, you're changing your position that you consider the contention now not admissible.
Initially, we had filed saying we found a portion of it admissible.
Correct.
We're changing that to say we're just not responding. We're not taking a position on that contention.
You're not taking a position one way or the other. Okay. Thank you.
Perhaps we can come back to that, or Tim and Kim are both looking for the references.
Okay.
Let me just clarify what I said. It's in the Chapter 1 introduction to the ER, and it says, quote, Holtec is currently requesting authorization to possess and store 500 canisters of spent nuclear fuel containing 5,000 metric tons of uranium. However, if you look at your proposed license, it says 8,680 metric tons. So there seems to be a disjoint between the ER and the proposed license.
Yeah, my understanding is the appropriate number is 8670 metric tons. I don't know if the 5,000 is still in there.
Well, the
in
5,000 is consistent with the eventual goal of 100,000, but the 8,680 is consistent with the number interveners were saying of 170,000.
Right, and the assumption is that all canisters are equal, and all canisters are not equal. In fact, the earlier canisters, which will be Holtec, will have more fuel in them because they have greater capacity than the average of other canisters. So on an average basis, the 173,000 number is wrong because the later canisters are expected to have less fuel than the earlier canisters. I think that's the clarification as to why there are different numbers.
Thank you, Mr. Silver. I think you're still researching an answer. Is that correct?
Yes.
This could be maybe a good time to take a little bit of an early break. Yes.
I also have looked at different documents for different numbers about how many metric tons, and I just want to read for Judge Arnold a sentence from page 1-1 of the environmental report. It's in the middle of the page. It says, Holtec is currently requesting authorization to possess and store 500 canisters of SNF containing 8,680 metric tons of uranium, MTUs. So that number, 8,680, appears on the first page of the environmental report. It is revision 3, but I believe it's in earlier revisions as well.
Thank you. We have a request here from NAC's counsel. I think we're going to take a break shortly. If you have a minute or two that you can respond, wish to respond.
A minute or two.
Okay, go right ahead.
So a lot of their reply regarding their answer regarding your question relates to the scope of the ER for an amendment. They say that they'll need ER for an amendment, and our reply is they didn't say that ER would get to facility design alternatives. I want to cite to just, I think you'll find a lot of cases that get to this point. Turkey Point, LBP 90-16, 31 NRC 509, Westlaw didn't give you the page number for this one, 31 NRC 509. The statement says, the scope of a National Environmental Policy Act, NEPA review, is more limited than one formed prior to initial licensing. And it cites to other decisions, LBP 8114, 13 NRC 677. There's other decisions that get to the fact that an environmental review for an amendment is limited. It's linked to the consequences of that amendment. For an amendment for a cast canister, it would be limited to the cast canister direction. And that makes sense because when you have a power plant, they get amendments all the time for a license. There's an amendment proceeding. You don't get to go back to that amendment proceeding and redesign and litigate the design of the power plant. In this case, the facility, the ER, is going to govern the whole facility. They said that. So whenever this amendment happens, Amendment 3 gets passed or later amendments to put in NAC, the facility will have been designed and will have been built. So there's no ability to litigate the design alternatives. And then, on the contra side, look at it this way. If we challenge the design alternatives later, we're going to run into this ironclad obligation that is well discussed. Because we know everything now. We know that they know their design approach. We know it involves the universal cast, which they acknowledge is comprehensive and take other canisters. In addition to their point, look at 2.2.2.1 of the ER, which says what universal cast is in more detail. And they're going to know all the information we need at this point to file contention. about the design alternatives analysis. So later on, what are we going to really get out of this that's going to prevent us from running to this ironclad obligation analysis?
All right, thank you, Mr. Silver, did you want to say something before we take a break?
2 points. First, I didn't think we were going to get into a debate on individual contentions, but there's again, I would like to respond to NAC Council. The idea that we will fully design and build the facility when this issue might come up, we won't have built the facility. Phases, whatever phase we're seeking approval for, won't have been built at the time that change comes forward. And the idea that we have to consider as a design option putting our competitors' facilities on our site makes, frankly, no sense at all. It's as if we wanted to build a reactor with a Westinghouse design, and GE came and said, we want you to evaluate putting a GE plant on that same site. Well, that's not the purpose of this project. It's made very clear the purpose of this project is to deploy Holtec technology. They want to talk about alternative technologies and alternative sites. It's not the competitor.
All right, thank you, Mr. Silver. Let's take a break now. Let's go to promptly at 10:30, and we will resume then. Mr. Taylor.
Mr. Chair, before we move on, did I clarify something that was discussed about the Baltimore fire operations?
Yes.
Is it working? Yeah. I believe Mr. Silver made a comment before the break that not to mention cost of report. I got
Hello?
Definitely works.
Okay. Before the break, Mr. Silver made a comment, I believe, as I understood it, that the Baltimore fire report by Dr. Resnikoff was not relevant because that was not a route that was being considered for the Yucca Mountain project. It's my understanding that that report was a response to the 1999 Yucca Mountain EIS draft, which did have the Baltimore Tunnel as part of the route to Yucca Mountain, and that in response to Dr. Resnikoff's report, the route was then modified for the final EIS.
Thank you, Mr. King. Back to Holtec. I think you were looking for some information to give us.
Yes, sir. Yes, Your Honor. With respect to the decommissioning cost estimate, Table 9.1.4 of the decommissioning plan provides the Holtec estimate for the decommissioning cost for Phase 1, $23.7 million. Section 2.2 of a separate document, the life cycle cost estimate, says we need to collect $840 per MTU to meet those decommissioning costs. You have to use the 8680 MTU number to get to that number. So that's why the decommissioning cost estimates that we provided were based on the intended capacity of Phase 1. And the ER Rep 3 does have the correct number as far as holding the 8680.
Okay, thank you. I think I have one more area for questions myself, and I think there are some questions from some of my colleagues, particularly on the geology issues. My question is on standing. I want to understand Holtec's position on standing a little better. Holtec's position is that none of the 6 petitioners has standing, and NAC is kind of a different case, but oh, I don't know, Beyond Nuclear has a member who lives a mile, I believe, from the facility, and I'm not quite sure I fully understand Holtec's position on standing. I guess my concern, to give to you, is that is Holtec arguably conflating the test for admissible contention with the test for standing? I know the Commission tells us that when we consider standing, unlike when we consider contentions, we should be fairly lenient in finding standing. And if someone lives a mile from the facility, do they have to establish a pathway, a possible leak from the facility? If you're putting all these metric tons of uranium practically in their backyard, doesn't that give them standing? Would you like to explain a little more why even those who reside very close to the proposed facility, in your view, do not have standing?
Thank you, Your Honor. Yes. Our position is that the Commission requires a case-by-case analysis of standing and materials license cases, and specifically, it is the petitioner's burden to show that they would be impacted by the facility, and in this case, they have not done so. There are several reasons for our position. It is true that petitioners are obligated to demonstrate some sort of plausible mechanism by which they would be impacted by the analysis, and there's Commission case law on that. In particular, the U.S. Army Installation Command case, which is a case cited by several of the petitioners, where the Commission rejected standing, where it found that there was no obvious potential for off-site migration of the radionuclides in that case. The Commission has also issued some rulings with respect to, what type of dose has to be received in order to constitute a harm. And their Energy Solutions case in CLI 11-3 says mere potential exposure to minute doses of radiation within regulatory limits does not constitute a distinct and palpable harm on which standing can be founded. The SAR, Table 7.3 of the SAR, gives you the dose at 1,000 meters or a kilometer away, and that is 0.0848 milligram. And no one has asserted that they reside closer to that there. And that's assuming continual 8,000 and change hours of occupation. It's a 24/7, 365-day-a-year analysis. There's been some discussion, too, about some of the case law in here, in particular the 17-mile radius that was established in the Diablo Canyon and the Sheeran Harris cases. Those cases are easily distinguishable from the one present here. Sheeran Harris involved a spent fuel pool expansion proceeding. And in that case, the activities that were going to be licensed involved actual handling of bare fuel, having it shipped in transportation casks, unloaded and put into the spent fuel pool at the Harris plant site. In the Diablo Canyon proceeding, while yes, that was an at-reactor independent spent fuel storage installation, the license action there involved, first and foremost, an above-ground independent spent fuel installation, whereas the one that we propose to build will be below ground, and therefore has a significantly different risk profile. But in addition, the licensing action in Diablo Canyon involved the placement of spent fuel from the spent fuel pool in the canisters, and then moving those canisters on the pad. Those operations are not present here in this proceeding. The canisters, as my colleague said in the very beginning, are going to come to the site sealed and will not be opened. And so our contention is that petitioners have not demonstrated that that case ought to apply here. And again, I think it's incumbent upon the petitioner to show in a case-by-case scenario why that ought to apply here, and we don't think it does.
I guess the problem I potentially have with that position is that I have a hard time imagining who would have standing. You say that the canisters are not going to leave, the casks aren't going to leave. But can you tell me who might have standing? Can you think of anyone who would possibly have standing under your theory?
Your Honor, it's petitioner's burden to demonstrate they have standing. We've laid out all the facts that are appropriate here.
Okay. Thank you. All right, I think, Judge Gross, did you have some questions?
Yes. Unfortunately, many of my questions have already been answered, which is convenient. We started a discussion yesterday with the Don't Waste Michigan group regarding their contentions 5 and 12. And I had asked the question, would subsidence on the site potentially cause damage to the UMAX storage system? And the answer, of course, came back yes. I will ask you the same question, and I'll add to it that if you tell me that the design of the system incorporates subsidence as part of the design basis, then perhaps the answer to that question is no, but what is the correct answer?
The correct answer, we believe, is that there will be subsidence on the site, and we've provided information in the environmental report, which also refers to the OLEA 2007 report, which underwent a detailed analysis of the site itself, looking for evidence of subsidence, and this is specifically the site, not West Texas, which interveners or petitioners have used as their basis for subsidence. They refer to West Texas, and we're looking at the actual site itself. And it goes back about 50 years worth of what they're looking at, and there has been no evidence of subsidence at the site that we've seen.
So you're saying there won't be subsidence, and you don't have to account for it for that reason?
We believe that it's not a credible threat.
It seems like the SAR, I think, agrees with you on, I think it's page 2-54, I mentioned it yesterday, seems to indicate the same as what you're saying. However, the ER does have places where it seems to indicate that subsidence is possible. Page 344 to 345, again, that's a PDF reference. It's the section that says Pecos Valley section and physiographic subregions. It says solution subsidence depressions of varying sizes are common landscape features across this section because of the dissolution of evaporating carbonate units.
I'm sorry, Q 344 and 345 of the document that I'm looking at appear to be graphs.
Well, we made this, okay, so this is a PDF document, and the one I have is obviously different than the one you have. The section is called Pecos Valley section and physiographic subregions. That's the section name.
Is it possible that you're looking at Rev 3 of the document?
No, I'm not.
Well, in the area there has been subsidence in the general Permian Basin region. Without looking at the document itself and finding the page, and I might have to get back to you a little bit later, I can't tell you specifically if this is near the Holtec site. We haven't seen subsidence near this. Yes, subsidence near the Holtec site. However, in the overall Permian Basin region, there has been some. It's typically more associated with the potash mining that occurs in the area, which is why in section 3-2 of the, or page 3-2 of the ER, we reference that Holtec holds the mineral rights for potash mining down to 5,000 feet, which is why they don't expect subsidence. Once you get below that level, you don't expect subsidence to occur, and in fact, the Schaefer's-Been report itself indicates that activity below 3,000 feet would not result in subsidence. He says that on page 15.
All right. And I bring this up because, of course, it's Don't Waste Michigan, two contentions specifically deal with this. We learned yesterday from Mr. Lodge that there's an RAI that was issued recently, well, I guess it was March, that dealt with this, and we hadn't, I hadn't seen the RAI or any answers. So this was all news to me. But subsidence, it would be a common mode failure in risk parlance. It wouldn't potentially fail one canister, it would fail all canisters, all casks, perhaps I should say. So it's a serious matter and not one that should be lightly dismissed.
Your Honor, the RAI in question, the RAI in question was issued in March of 2018 of last year. It was responded to in May of 2018. The interveners, the petitioners had the opportunity to address that RAI in their contention if they so choose, and they did not. We can probably provide an ML number for you with a bit of looking. In terms of the risk of subsidence, again, we do not believe that a risk has been substantiated at the site. We do not believe the petitioners have put forth a risk. And given that Holtec controls any mining rights down to 5,000 feet and that there has been no evidence of past subsidence, we don't consider this a risk that is credible.
Okay, but the petitioner did put forth a challenge to that in contention 5 and 12, right, correct? And they do have an expert who supports their position.
The petitioner's own expert indicates that there is no risk if the drilling occurs below 3,000 feet and we own the mineral rights down to 5,000 feet.
With respect to hydraulic fracturing,
we own the potash mineral rights down to 5,000 feet. Potash mining occurs above 5,000 feet, traditionally in the 1,000 to 2,000 range. As petitioners even note in their own report, oil and gas drilling occurs much lower, generally 8,000 feet.
and what about contention 12 with respect to the geology below the site? Their expert, Dr. or Mr. Schafferson, I believe it is, indicates that the nature of the geology of the site is significantly different than what's mentioned in the ER. I think I mentioned this yesterday, but comparing section 3.3.3 of the ER with section 2 of the, I guess I would refer to it as the Schafferman report, are in direct contradiction with respect to the occurrence of karst in the geology of the site. And my understanding is that the karst geology does lead potentially to subsidence. And also, subsidence has been shown to occur in the vicinity of the site. Now, you're saying it has not occurred at that exact spot.
And there's a lot of data to support that assertion. I don't read the Schaefersman report as asserting that there is karst specifically at the location. In fact, I believe he says that there is not. What he does point out is that there is a salado area below the site. I believe he says that it starts at 1,400 feet. And he alleges that the salado area may grow into karst if there were leaking oil field waters, old brine injection wells, or broken casing, causing a dissolution cavity to develop in the salado. I don't see any specific references to particular karst formations at the site itself. However, I would say that these are all speculative. He's assuming that a series of events may occur that have not occurred at the site, and all of this, again, is contrary to the evidence at the site that there has been no substance there. I don't see anything in the Schaefersman report that specifically points towards karst at this specific site. He does say, of course, that it's in West Texas, and it's in other areas of the Permian Basin, which we do not dispute. I will make a note that the basic geologic data on page 13 of the Schaefersman report, to the extent that you're relying on it, this is geologic data for well CP975. That is not a Holtec site. That's actually at the border with Texas. It's somewhat unclear from the report where that's located.
Yeah. I'm not relying on it, the petitioners are relying on it. Okay, well, I understand, but, you know, we do have a contention, we have two contentions that deal with this, and they are supported by expert opinion.
Well, we disagree that the Schaefersman report supports the existence of cars at the site or subsidence at the site.
But right now, we're not in hearing,
Well, the petitioner's own documents can be reviewed to whether or not they support the contention. In fact, the petitioner's documents that are put forth in support of a contention should be reviewed to determine whether or not it prevents an adequate basis for factual or expert support.
okay, but that's fine, at this point, that's enough. But I will, again, remind you that we were told yesterday that the staff is looking at this as well.
Just as one last comment again, that RII was from last year and it has been responded to. We can get you the ML number if you wish.
Yeah, I hope
We'll look for
you
it.
can, yeah. All right. Okay, I'm going to jump around a little bit at this point.
If it's geology, it's still me.
No. It's, I have other questions.
Why don't you continue?
All right, I'm just going to try to fill in gaps that I have. With respect to the start clean, stay clean question, if a canister doesn't meet the receipt and inspection procedures that Holtec has, the plan is to ship it back to the center. Would there be, and of course it would have to be the requirements of Tennessee or something. If it doesn't, if it can't be shipped back, and I assume that may happen, there's no indication that it couldn't happen. What would happen at that point?
Your Honor, we don't anticipate it happening at all. If a canister is found to be leaking or damaged in any way, it will be shipped back in an NRC-approved transport cask, and it must be shipped in accordance with Part 71. And we can't imagine a circumstance where a canister that doesn't meet our requirements would not be sufficient, where when inserted into the transportation cask would not be sufficiently protective. But we would take whatever steps are necessary to ensure that it could be transported back to its originating site.
Do you have the ability to, for let's say canning or anything like that at the Holtec facility?
No, we do not.
I will make one further point, that is, you can insert a Holtec canister into a sleeve if there's a problem with the canister before it's put into the vertical shaft. The shaft has enough clearance to support an additional canister before it's temporarily set in the vertical shaft.
Your Honor, I don't know if an objection is appropriate, but this is the first time I'm hearing something from you.
Yeah, excuse me, Mr. Lodge. You might ask for the opportunity to speak.
I'm sorry, my apologies. I may have heard it wrong.
Yes.
Thank you.
This is the first time we're hearing this information. We're trying this case, we're trying things on the merits, and so it seems. Certainly there is a problem of conflating standing and merits kinds of issues I've been hearing this morning, but this is new information. And a representation of counsel, certainly nothing we've seen in the documentation. That there's some sort of mitigating methodology that's available if there is a troubled canister that is delivered to the site.
Is that your point?
Yes.
Okay, thank you.
Your Honor, we have an ML number available for you for that RAI response, if you're ready. This was RAI 2-2, and the ML number is ML 18150A330.
That was ML 18150A30.
A330.
Okay, thank you. Okay. In your answer to contention 23, you state that the system allows for ready retrieval of the spent fuel from the storage system for further processing or disposal. Can you tell me what you mean by further processing or disposal?
Your Honor, that simply means removing it from the storage module and sending it to a repository as its equivalent. Taking the canister out of the module and sending it to its ultimate disposition.
Regardless of its condition?
It's supposed to meet the staff's interim staff guidance too on retrievability. That's why we state that in there. Prior to transportation, the canister will have to be inspected again to meet the requirements of Part 71.
All right, so what you mean is shipping it off-site to a disposal facility.
Correct.
That's what that means. Okay. That's fine. With respect to high burner fuel, is meeting the requirements of interim staff guidance 11-3. We talked about this yesterday with perhaps Mr. Locke. Is that sufficient to maintain safe storage for, let's say, the service life, 100-year service life? Just simply meeting those temperature requirements are sufficient?
We believe it's sufficiently protective of the cladding, yes, Your Honor. In addition, we also meet the ambient temperature requirements as well too, with some margin. So there's less likelihood at the site itself. Therefore, there's less likelihood of potential degradation due to temperature-induced degradation.
All right. So from your point of view, as long as you maintain the fuel within certain temperature limits, high burner fuel can be treated as the same as lower burner fuel.
Yes. In addition, Your Honor, I'd also like to correct something from yesterday. There is the aging management program for high burner fuel, which is not a voluntary program as was stated. It will be part of the license requirements of the facility. That is a program that's going to basically incorporate data that is learned from the Department of Energy and EPRI, and will take whatever protective actions are necessary. But the assertion yesterday that it's a voluntary program is flat wrong.
Okay, I guess we did discuss that yesterday with Mr. Lodge. And you're in a position to implement anything that comes out of these research programs that are underway?
Yes. That's our position.
Thank you.
Concerning high burnup fuel, now, your canisters are certified for the storage of high burnup fuel, right?
Correct.
And the transportation casks are certified for transportation of high burnup fuel.
Correct.
Now, is it your assertion that these certifications pretty much put all of the questions on high burnup fuel out of the scope of this licensing action?
The design-related issues are outside the scope of this action. We still have to evaluate, as we did, the environmental impact of storing and transporting spent nuclear fuel, and that's what we did.
I'm just wondering, is there some rule that tells us that these issues being certified are no longer within the scope of this?
Yes, Your Honor. Rule 72.46E of the Commission regulations deals with the storage question, and it specifically states that if an application for a specific license incorporates by reference a design of a spent fuel storage cask for which NRC approval under subpart L has been issued or sought, the scope of any public hearing to consider the application will not include any cask design issues. And then with respect to transportation, it's a similar analysis, but different rules apply because we have the transportation certification and we are allowed to transport spent fuel under the general license. That general license is not subject to challenge in this proceeding.
Thank you.
Okay, let me continue with high burner fuel discussion. There's a table in the UMAX FSAR. It's table 5.0.1. There's also a table 7.1.1. And the table 5.0.1 and the subsequent table define what they call a design basis fuel burn. Actually, it says design basis fuel burn up, cooling time, and enrichment. The table 5.0.1 is referring to an MTC 32 and also the MTC 37 canister. And it has a burn up of 45 gigawatt days per metric ton range, which is defined as the threshold where high burner fuel begins. It also has a cooling time of 5 years, and it has an enrichment of 3.6%, which is less an issue here. And the other table, 7.1.1, has a burnup of also 45 gigawatt days per metric ton, a cooling time of 8 years. And I guess my question is, why would you set a design basis to be the minimum threshold of high burnup fuel? Again, before you answer that, there's also in the certificate of compliance document, let's see if I can give you the exact reference. This is certificate of compliance for the NP37 canister. That certificate of compliance had some appendices attached to it. Appendix B is entitled the Approved Contents and Design Features. for MP 37 canister, the maximum enrichment is 5%, which is certainly acceptable. The cooling time is greater than or equal to 3 years, which is also acceptable. But the assembly average burnup is less than or equal to 68.2 gigawatt days per metric ton, which means, of course, it could be 68.2. So how do you reconcile? And this Appendix B is the references given for what should be acceptable to your site for an MP 37. There's also an MP, the MPC 89 portion of that. It's very similar, but it's 65 gigawatt days per metric ton, so it's slightly. So you have a design basis assembly of 45, and you have assemblies coming in that are, let's say, 65 or perhaps more gigawatt days. How does that all work?
Just to confirm, you referenced table 5.0.1 from the UMAX FSAR, and you mentioned also a table 7.1.1. Is that in the same document?
I believe so, yes. In fact, it is.
That might be the highest score.
I believe it's identified as the UMAX FSAR.
We don't have a table 7.1.1 in the UMAX FSAR.
We recommend that we take a moment.
Let me take that back. The first table is the UMAX FSAR. The second table is the CISF. Yes, that's correct. FSAR.
Can we take a moment to research and get back to you?
Sure.
We could either do that over the lunch break and continue now, or take a break now and place it.
It might be better to do that, to give you the time to do that, unless it's going to be very quick.
Yeah, so, I mean, do you want to continue with your other question?
I think we have the answer.
Okay, good.
The answer is that source terms and doses are based on a combination of burnup, enrichment, and cooling time. The chosen mix is reasonably bounding. Burnup alone does not determine dose for the spent fuel.
Okay, but it is a factor.
Yes, it is.
It's not all, but it is a factor.
Yes. But the certification for the UMAX system is up to, is capable of storing the NPC canisters. That is specifically stated in the certification for the UMAX.
All right, so in other words, that 65 or 69, depending on which canister it is, can be accommodated safely. And the fact that the UMAX table 5.01 calls that a design basis assembly of 45 is not what goes into the analysis. The analyses are done to accommodate the higher burnup, the highest burnup you can accommodate, which apparently is 65 for the NPC.
Hold on a second.
We'll come back to this, Your Honor.
Okay, all right, that's fine. Your ability to remove, to retrieve canisters under all conditions of storage, those are, I believe those are your words. Certainly they're referenced by the staff at various times, and we just talked about that. Your environmental engine, your on-site radiation protection program is capable of accommodating any condition of a canister when it's retrieved for disposal. Is that correct?
Yes.
That's correct.
Yes.
So no matter what cracking you might see, no matter how much failed fuel there may be in a canister, you can retrieve it safely and send it off for disposal.
I assume that there's a credibility issue here. One can postulate the meteorite hitting the cask dead on.
Let me correct that. I'm talking about all normal conditions of storage over a long period of time.
Correct. That's correct.
Because we do have a service life issue, or a defined service life of 100 years.
Yes.
All right, thank you. If a leak occurs in a canister while it's in the UMAX enclosure, can it be identified?
We would expect, we wouldn't expect any leaks, but the aging management program is specifically in the application to deal with those kinds of circumstances.
And, you know, I do believe, from what I've seen, that you would lift the canister out of the enclosure and inspect it as you bring it out at various levels to see if there's any cracking. Is that correct?
The monitoring would be visual. There's an annulus between the canister and the cask wall, and the monitoring would be done visually, remotely visually.
Right.
We're not sending people down there, but we'll send equipment down there.
Right, so you'd be lifting the canister out and visually inspecting the
Well, I
canister.
think you might visually inspect it before
So,
you lift it.
so you could send the camera down and visually
Yes.
inspect. Okay. Can a leaking canister be repaired?
The answer is that it's outside the scope because there are no credible paths.
Okay, I take that as a no.
At the present time, it's not within the scope of this license application.
Hypothetically, if a leak did occur, could you put it inside another container?
That's what we talked about before, where you have the encapsulation and the vertical casks have enough clearing to insert an over canister, over the canister and inside the vertical module.
So any assertion that you had no way to handle a leaking canister is incorrect?
That's right. The question was, can you repair a cask? And that's really outside the scope. But that's not to say that you can't take steps to remedy a problem, even if something happens that we don't consider credible, which is a leak through the cask.
Can you remove the fuel from a cracked canister and put it in another canister?
If you have the right facility, yes. But That's not part of the design of iStore.
Well, I think you've answered my next question. Have you seen any cracks in canisters in the past? Sounds like you said no.
No, there have been none. The question about removing fuel is the dry transfer storage discussion that we had yesterday. It is a technique that is possible. It is not part of the design. The design would have to go through a licensing process. That's stated very clearly in the continued storage rule that adding a DTS would be a licensing event.
I guess the problems with saying are no free, are they applicable here?
Yes.
I'm not very familiar with the problems.
Yeah, the answer is we believe no. The standoff pins are no longer being used in current manufacture. There are all, I think, 42 casks that have those. The problems in Santa Fe, we do not think are relevant at this site.
The aging management program, not specifically the high burner fuel one, but the standard aging management program, does include testing of groundwater. And can you tell me what that means? Because we have an outstanding contention that claims that there's groundwater that you have not, that you don't know is there, so to speak.
Well, we have existing wells that have been monitored that have identified groundwater. The results of that are set forth in the application. I don't know off the top of my head what the aging management plan says on that specific topic. We can certainly find that information and get it to you.
Yeah, it didn't have a lot of details. It basically said we'd be testing the groundwater. It didn't identify, I don't think it identified specific wells or anything like that. I don't even think it identified the groundwater specifically, if it was talking about aquifers or, but again, you know, we've been through so much material, I can't remember the details of it. But if there were near surface groundwater, do you believe that the aging management program would capture that?
We do.
And in terms of cracking of the concrete support plate, the bottom concrete support plate, if there were a crack in that, water would get into the annulus between the canister and the UMAX enclosure wall. Do you monitor that for moisture?
Well, first of all, my understanding, I stand to be directed by our technical experts, is that groundwater is not at the level of the bottom of the vertical canister. I don't know how far below it is. We don't have the number, but it is not at the level or above the level. So, A, there is no known mechanism for getting water. B, there is no mechanism for concrete cracking. Whether or not we monitor the bottom of the annulus or the bottom of the vault for water, we don't currently monitor that.
You don't monitor.
No.
But you can't put a camera down there to look at the canister wall, so therefore if you saw water, I assume you would take action.
We would indeed.
Okay.
And to our knowledge, those kinds of requirements are not imposed on the current in operation UMAX systems at U.S. plants.
With respect to the question of brine being in groundwater, I believe that your aging management program, groundwater testing, does include brine testing. Is that correct?
Yes, that is correct.
If there were a crack in the spent fuel storage canister, and I understand there's never been one and you don't anticipate one, would that result in a release of radioactive material, or would there be a need for further fuel damage internal to the canister for a serious release?
To the extent that there's been allegations of a release that's liquid-based, we don't believe there's any mechanism for there to be such a release, given that there is no liquid stored at the facility. In terms of I'm not sure, in terms of dose, is that the other question?
Well, so if there were moisture in the annular region and it caused the corrosion of the canister and the canister crack, there would be no liquid release. There would only be fission product gas release, correct?
That's correct. There are no liquids.
We have a contention that talks about the near-surface groundwater. Do you have anything more to add on that regarding the presence of near-surface groundwater?
In terms of near-surface groundwater, we believe that the only groundwater that has been located was in well OEA 2, I think is the number. And it was first identified at a depth of 90 to 100 feet, and of course it welled up to about 35 feet, I want to say. But the other wells that were drilled, including in the GPI report, did not encounter any groundwater at those levels. They were looking for groundwater as they went down. As we detailed in our response, they took sputum samples, but there was no other groundwater at a near surface level that was identified at the facility.
And I think your answer to that contention, I think it's contention 15, Sierra Club contention 15,
yes,
supports
that. Yeah.
Yes. There was a discussion yesterday regarding hypothetical accident conditions versus real-life accident conditions. Can you address that with respect to what you've done for your for your canister and cask design? Do you do any kind of computer code about analyses? Is that part of your design basis?
Well, certainly computer code analyses are part of that basis.
Okay. That would be hypothetical accident.
For transportation casks, we have done physical tests, yes.
So for what were termed hypothetical accident conditions, you do computer code analyses. For real-life accident conditions, you put these canisters and casks through testing requirements, physical testing requirements as required by the regulation.
That's correct. I mean, there are many tests that have been done on canisters, casks over the years. That data is certainly included in the way that these casks, new casks, are analyzed. We don't necessarily test to failure every cask design, but there have been those tests in the past, and the results of those tests are certainly incorporated in how casks are designed.
The thermal analyses that you do to assure that you don't exceed the, I'll say the high burner fuel temperature limits, but I mean it for both high burner and non-high burner fuels. Those analyses, are they computer code analyses, or do you do any actual testing?
Computer analysis.
Okay. Do you do any kind of data capture when they're in the enclosure to make sure that your computer code is correct?
We have benchmarked in the context of the UMAX design. There have been benchmarking tests that are done.
So you have experimental data that you correlate your computer codes against?
Yes. I apologize for turning around, but I don't like to give those technical answers based on my technical.
Please, I'm happy to have you turn around as much as you need to. The contention, Sierra Club contention 21. That's dealing with this question of transportation of high burner fuel, and that it would be dealt with on a case-by-case basis. Can you say anything regarding that as it applies to your storage facility?
Well, as I understand it, the certificates of compliance for UMAX, for the transportation cask, and for the canister all include high burn-up fuel. So to that extent, they are currently licensed and approved by the NRC, obviously. And at the present time, there's no more that is required. We have met the NRC's tests, we have met the regulatory criteria.
Okay. You also answered earlier that all of the new research that's going on, that you're plugged into that research, and that you would be required to make changes as indicated by that data?
As necessary, the aging management program will incorporate the results of the DOE EPRI program on high burn-up fuel. Those results will be incorporated as appropriate.
You don't have your own demonstration program for high burner fuel?
No. I think the DOE EPRI program is intended to be an industry-wide program with wide participation by the utility vendor community. DOE and EPRI, I believe the NRC is an observer to that program, or perhaps even a participant in it. Certainly they're aware in detail of what's going on.
All right. The interim staff guidance seemed to imply that they had a fairly active role in it, because I think that's part of the case-by-case basis discussion. But
that's right.
A number of these questions are going to have to be asked again. transportation within the facility? In terms of contention 21, is that,
Well, generally, I don't know in this particular case, but transportation within a facility, a Part 50 facility, where you're moving casks from the reactor building out to the SOC, those don't require Part 71 approvals. My understanding, they're all done under the Part 72 license. The transportation down the Hall Road using the vertical crawlers as appropriate are reviewed by the NRC, but I don't believe that it's part of a Part 71 program, if that's what the question is.
yeah, that was the question. Part 71 does not apply.
Correct, until you go off-site.
Correct. Okay. I think I'm okay for now. Thank you very much. I do have some questions, and I'll be asking some questions similar to Judge Tricurus, who filter them out. That would do with Sierra Club contention number 2, the issue of safer and more secure. Do you explain in the environmental report what you mean by that?
Yes, we do. We explain why we believe, although at-reactor storage is safe, it's been designated by the NRC as safe, on an overall basis, the high-store facility will be safer and more secure. It's more secure because it's remote. It's safer because it's underground, among other reasons.
Did you intend for that statement to be inclusive of the transportation of fuel, or just once it's at your facility?
No, it includes transportation, and for that we rely on the generic analyses that say transportation of spent fuel is a minor environmental impact.
Concerning Sierra Club contention 4, having to do with transportation from the reactors to the CIS. Now, they fault your dependence on New Reg 1714, saying it is only for the regional transportation, not across the whole country. You state in
Is
your
that, is 1714, is that the PFS EIS? I believe it is.
C, and this is the C in Toole County?
Yes, that's PFS. 2L.
Toole, okay.
Close enough.
What exactly, now, in your response you said that looked at more than just the region.
Yes, my recollection is that contention said that EIS only dealt with local transportation, and that's incorrect.
Now, in this contention, petitioners appear to have a credible analysis of the radiological consequence of a transportation accident occurred while shipping spent fuel. On page 25 of their petition, they compare the results of that analysis to the results of your analysis and find their results to be orders of magnitude, 1,250 times the result that you have. Now, how can we not consider that a material dispute of fact with the application?
We believe you have to look at the document that they rely on to determine whether it is material to this proceeding. And we've had some discussions about why we respectfully submit that it is not. if they submit a material document, even though by a PhD, even though it looks like a credible report, and it may be a credible report, if it's not material to this case, it can't support the admission of a contention.
Concerning this analysis, I think it was yesterday you said, or maybe it was today, the temperature in that tunnel was greater than the temperature required for the certification of the cask.
That's my recollection, yes.
And you said that somehow using that fire would be a challenge to the rules.
Using the temperature of that fire to say that our transportation is inadequately analyzed is a challenge to the rule. Also, the conditions, as we discussed earlier, of that fire are not relevant for the reasons we discussed.
I'm more familiar with the reactor world than spent fuel, but in the reactor world it's been demonstrated several times now that actual accidents sometimes do exceed the design accidents. And so it seems to me we've got a historical fact that a fire on a railroad in a tunnel can exceed the design temperature. Does acknowledging historical fact constitute a challenge to a design specification?
Yes, and you have to also look to see whether that event is relevant, as we described earlier. The magnitude of that fire was a result of the combustibles. The combustibles in that tunnel on that day are not what you would have with transportation of spent fuel. Whether the design is sometimes exceeded in real life, we nevertheless have an NRC regulation. If the petitioners thought that that regulation was inadequate, they should have sought a waiver under the Commission's procedures. They did not do that. This is not new information. They've known about the Resnikoff analysis. They've known about the Baltimore tunnel fire. If they wanted to challenge the applicability of the regulation in this case, they have more than enough time to do so.
Concerning petitioners' claim that the railroad infrastructure is deteriorating, when it comes time to move spent fuel, will you be permitted to make use of any railroad track that is in place and available? Or is there some inspection? Do they look to see if the tracks have recently been certified? Or
as we discussed in our response, the Federal Railway Administration does that function for transportation routes over the rail. This will not be the first rail transportation of spent nuclear fuel in this country. Those procedures have been in place. They've been exercised. We've had perhaps hundreds of shipments over the rail of spent nuclear fuel in this country. We've had thousands of shipments over the road in this country. Worldwide, it's even greater. But yes, the rail infrastructure for a particular route will be inspected at the time the route is chosen, the time the shipments will take place.
So a railroad track that is today in excellent condition, but is in the future, deteriorated, that could be okay for shipment now, but not okay when you go to the Part 71 shipment process, and it would be precluded from use.
And vice versa.
Yes. So now is not a good time to be determining the condition of railroad tracks for future use.
Now would be a very bad time to do that. In this country.
Sierra Club Contention 9, the ER must examine the environmental impacts of the containers being used beyond their approved service life. Do you anticipate there will be any time where you have spent fuel stored in a container whose certification has expired?
No, because we would apply to extend that certification. which point it would be reviewed by the Nuclear Regulatory Commission.
And you have a system in place that will assure that's done?
We are obligated to meet our license conditions. One is when a license expired, we will file in advance because we want to take advantage of the timely renewal doctrine. Also, this brings into play the continued storage rule because we do not have to look at environmental impacts beyond the license life.
Concerning Sierra Club Contention 11, concerning the potential consequences of an earthquake, does historic data account for the possibility that recent and future oil and gas drilling may affect earthquake frequency or severity?
We believe that. We believe that it does. There's been drilling in the area, as is mentioned in the expert report, used by petitioners for over 40 years, I think over 50 years. There's no reason to believe that the current historic data does not encompass drilling. In fact, the expert report put forth by petitioners does not have any more recent earthquakes than the 2012 earthquake that we already analyzed for. In addition, we believe that the report put forth by petitioners does not support that there will be more earthquakes in that region going forward. If you read it in a great level of detail, it actually finds a low slip fault potential in the area of the Holtec site. So we don't believe it even supports their assertions.
Does it support any increase in the severity of ground motion of earthquakes?
No.
You have some sort of design ground motion?
Yes. In fact, there's the design ground motion for the high storm facility, which is, I believe, between 0.7 G and 1 G, depending on the acceleration and the orientation of the ground motion. The bounding analysis for the site is referred to as 0.25 in every direction. That is far greater than what the USGS returns for the site, which is only 0.04 to 0.06 G. So that's the UMAX high storm design well bounds any potential impacts from the site.
So you're saying the design ground motion is not a close fit to historical data, but is in fact has some margin?
It's significantly larger.
Judge Arnold and I agreed that this might be a good time for lunch. We're obviously not going to finish this morning. I'm very optimistic we will finish today. So we'll take an early lunch again, I think, because with no cafeteria in the building, people have to go out for lunch. We'll take about an hour and a half. So why don't we plan to reconvene promptly at 1:15? Almost there. Couple of items before Judge Arnold continues his questioning of Holtec. I wanted to alert the NRC staff of the questions I will have when we get to you, in case you need to either think about them or look them up. My principal area of questioning pertains to the filing that you made on October 9. I believe the staff either would have admitted in whole or in part, or at least would not have opposed the admission of 6 contentions, 2 of which are essentially the same. And we talked a little bit over the last 2 days about possible changes of position on some of those. And I think it would be useful to go through, not now, but when we get to you, go through exactly what your position is today on the admissibility of those 6 contentions, and if you change on any others as well. But we'll do that later. I just wanted you to know we're going to ask about that. And then I think before Judge Arnold continues, there was an answer Holtec was going to give to Judge Kuros.
Yes, thank you, Your Honor. Before the lunch break, Judge Kuros asked a question about the design basis fuel analysis from the UMax FSAR, the iStore FSAR, and you quoted the numbers from table 5.01 from the UMax and table 7.1.1 from the iStore. And that this was tied to the high burn of fuel, if I understand your question correctly. The design basis in those documents did use a 45 gigawatt day burn up for the calculation. It's important to note, first of all, that the burn up level of the fuel isn't necessarily bounding. And that's the purpose of the design basis calculation, to get us a bounding number that will reasonably approximate a high dose rate. And so we use the design basis numbers in the calculations, the high burn up number, the number of years of cooling, and the enrichment level of the fuel as the basis for our calculations. We need to look at multiple parameters of the fuel in order to give us what we think is a reasonably conservative dose estimate for these purposes. At the end of the day, the NRC found the analysis that we performed to meet the requirements that are stated in the certifications for both the UMax and in the UMax FSAR, which is 3 years minimum cooling time, 68 gigawatt days burn, and 5% max enrichment. The key phrase in the NRC's conclusion in the certification is that the analyses we performed, and this is from section 6.4.4 of the staff's safety evaluation report, is that with the analyses that we performed and the conservative loading assumptions that we use, i.e., the canister is always going to be inside a system, we meet the requirements as stated in the certification. And therefore, we met the regulations set forth in 10 CFR 72.104.
So the analyses in the SAR, the two SARs, are conservative with respect to the certification. In other words, if 68 gigawatt days per metric ton fuel comes into the facility, it meets the requirements of the SAR.
Correct.
Okay, that's what I need to know. And that included the 3-year cool time.
Yeah, it has to meet the combination of the parameters. Yes, Your Honor.
Thank you.
Judge Arnold?
Okay. Sierra Club Contention 12 has to do with the dunes sagebrush lizard. Now, on page 50 of the petition, the Sierra Club states the 2007 report 2.6.1.1 lists the sand dune lizard as likely to be present at the site and vicinity. Now, that's a report that you referenced. Could you explain this in the context of your conclusion that that lizard is not present on your site?
Yes, Your Honor. My understanding of the report was that it found that it had not been observed, but also that the habitat that the lizard would seek out was also not present at the site as well too. So it wasn't just based on a no sighting criteria. It was, we don't have the type of habitat that that lizard would prefer on the site.
Concerning Sierra Club Contention 18, the Holtec ER has not adequately determined and discussed the possibility that waste-contaminated groundwater would reach the Santa Rosa Formation. Now, is it the certification of a high storm system that states there is no plausible scenario for the release of radioactive material?
I believe that occurs in several different locations in the application, including in the SAR for the high store facility itself.
Okay.
But I can get you a specific reference if you'd like.
Yes, please.
Might take me a moment.
Now, all of the spent fuel that's going to be stored there is in the form of unprocessed, straight from the reactor spent fuel?
That is correct.
Could you briefly describe what material would the greater than Class C waste is? I mean, this is storage of spent fuel in greater than Class C.
Typically, greater than Class C waste would include activated metal components of a reactor vessel, a belt region typically. Also might have resins that are above the low-level waste Class C. I think people tend to downplay that now, so that's much less significant.
Okay, and will any of the stored waste be in liquid form?
No.
No.
Let me also note that this phase 1 of the application, does not include GTCC.
Thank you.
GTCC is greater than Class C waste.
See, concerning Sierra Club contention 20, it's a high burnout fuel question. Now, Appendix B of the certificate, where the MPC 37 says it's an average burnup of 68.2 gigawatt day per metric ton. I assume then that there would be some higher burnup and some lower burnup to come up with that average?
That's my understanding, correct.
Concerning Sierra Club contention 21, having to do with no experimental support for the safe transportation and storage of high burnup fuel. Actually, what I want to get into is, what is the actual meaning to us of the certification of the high star 190?
The certification of the high star 190 means that it has been certified by the NRC to be capable of transporting fuel at the burnup level specified in the certification. So it's, and this certification is based on extensive analyses and tests which go into that process. Criticality, shielding, thermal evaluations, effective vibrations on the fuel, on the structural integrity, and the certification essentially says that there's not expected to be any damage in normal or accident conditions because of that.
Now, we already know that the certification includes some limitation on the burnout. Are there other limitations in the certification on use of that?
For the high star 190?
Yes.
They are nearly identical to, they are nearly identical to the ones we just discussed. And I think they're essentially identical. The minimum cooling time of 3 years, maximum gigawatt days of 68. I think that's for the, if you're transporting an MPC 37, which is the pressurized water reactor fuel assemblies. And I think it's a little bit lower for the BWR, and maximum 5% enrichment.
Is there a limit on the mass of material in it?
I think it's limited by the number of fuel assemblies that can be transported. 37 for the MPC 37 and 89 BWR for the MPC 89.
Is the safe transportation of high burnout fuel dependent upon the cladding remaining intact?
I do not believe so, but let me double check that, Your Honor. First of all, there is, the design and the analyses supporting the certification demonstrate, and the temperature limitations also apply as well too, which is the primary driver for cladding degradations, show that they're going to, the expectation that there will be no integrity issues for the cladding during transport. So the basis for the confidence in that is the underlying designs. But at the end of the day, you can still transport it if something happens to the fuel on the transport.
Let me add a little bit to that. Transportation of failed fuel is permitted. In fact, it's specifically called out in the standard contract for high-level waste and spent fuel between utilities and DOE.
Thank you.
Your Honor, I have a reference also for the SAR where it says that there are no liquid effluents. That's on page 193.
This might have been asked already. Sierra Club Contention 23, Holtec has not described how degradation that leads to gross ruptures in fuel would be detected. Do you have a capability to detect a gross failure of the cladding of the fuel?
The answer to that question is that we demonstrate we can't have degradation for the cladding of the fuel. And we certify the design to maintain the temperatures below which cladding is expected to occur. And in addition, the design basis heat load and the ambient temperatures for the facility itself are below those certified for the UMAC system. Therefore, we expect, at the facility itself, there'll be more margin protecting against such temperatures.
You earlier talked about the aging management plan. To what extent could that detect it, or just can't?
My understanding of the aging management plan is that it's going to be based on research ongoing with the Interim and EPRI, and the results of that research we will take whatever actions are deemed necessary to address the findings from that research. That's the basis of the aging management plan for high burning fuel.
Joint Petitioner's Contention 2 has to do with reasonable assurance for funds to cover the cost of construction, operation, maintenance, and decommissioning. You talk about the $840 per metric ton. Is there any way that you could end up receiving any spent fuel without having assurance of receiving that $840 per metric ton?
That would be a part of the contractual agreement between the owners of the fuel and Holtec. Stuff would not get on the road until that contract was enforced.
This has to do with Joint Petitioner, again, about the I'm a little lost.
While you're searching, can I ask a quick one?
Good.
Your answer about fuel won't move unless there's a contract in place. Did that include the plants you own?
We would be on the hook for that, whether there's a contract or not, since it's our fuel. I think the answer would be yes.
Okay, this concerns joint interveners contention 3. The environmental report is incorrect in that it contains a gross underestimation of the volume of low-level radioactive waste. I looked in the environmental report and I couldn't find a quantification of the weight of the mass of low-level waste. All I found was small quantities of it. Did you provide a number in the ER?
No, we did not. But I would note that the assumption that all the tons of concrete and steel that are used in the facility will become contaminated and low-level waste is without any substance.
Well, they challenged your underestimation of the volume, and you're saying you never gave the volume.
Well, we said it was small, and they said it's everything, and it's clearly not everything.
Okay. Well, for an industrial facility, what is a small volume? Is it cubic feet, cubic yards?
I guess you could the units of measurement.
For an industrial activity, how big can it be and still be considered small?
I guess it depends on the industrial activity. How much it would be in this, if you're asking us to quantify it at this point in time, I can't do it on the fly. But I will say experience with decommissioning nuclear facilities indicates that not every cubic yard of concrete and a piece of steel that's in the reactor building becomes contaminated as low-level waste.
Concerning joint petitioner contention 5, about the mineral interest below the site. On page 54 and 55 of their petition, the petitioners claim that you have failed to include in ER information required by 10 CFR 72.90 and 94. On page 56 of your answer, you addressed the first of these, and you stated where you had the 72.90 information, but I didn't see any answer to the petitioner's claim on 72.94 in your reply. In fact, 72.94 requires the region must be examined for both past and present man-made facilities and activities that might endanger the proposed IPAC, and the information concerning the potential occurrence and severity of such events as must be collected and evaluated for reliability, accuracy, and completeness.
That's correct, and we believe that we have evaluated the past and present activities that would endanger the proposed facility. As we have stated before, there is no danger to the proposed facility, at least not that's been established by joint petitioners, and the facility itself has been designed such that it can withstand significant earthquakes.
Would that information be in the environmental report or the safety analysis report?
There is a comparison of the ground acceleration for the site and the UMAX facility in the safety analysis report.
Joint petitioner contention 3, your future reprocessing facility. What plans do you have to reprocess the spent fuel?
We have no plans to reprocess the spent fuel.
Joint petitioner's contention 9, potential transportation routes. Actually, we've covered that adequately already. Joint Petitioner's Contention 11 has to do with transportation routes, and it touches on terrorism. Do you anticipate that your facility might accept spent fuel from San Onofre or Diablo Canyon or any place within the jurisdiction of the Ninth Circuit?
It's certainly possible.
Should this happen, hypothetical, will you rely on the current ER for that transportation, or will you be addressing the Ninth Circuit requirement somewhere else?
Well, we don't think the Ninth Circuit applies. I do believe we've addressed terrorism either directly or by reference to all the reports, many of whom have talked about terrorism. This is a facility that's located not on the Ninth Circuit, and we think that the appropriate circuit to look at would be the circuit in which the facility is located, or the DC Circuit as provided for by the Energy Act and other statutes.
And you believe that for spent fuel that's being transported within the jurisdiction of the Ninth Circuit?
Because the facility and the licensing action involves the facility that is not in the Ninth Circuit.
Could you repeat that answer?
Sure. This facility is not in the Ninth Circuit, and therefore the appropriate circuit law to look at is the law of this circuit. The NRC has said that, but for the Ninth Circuit, it will apply the court decisions primarily out of the U.S. Court of Appeals to the Third Circuit, and that will be the ones that NRC applies. Except as to those facilities, the NRC policy statement specifically says facilities as to cases that are referred to that policy statement. We're not licensing a facility in the Ninth Circuit.
I'm done with my questions.
Judge Carl, did you have any more questions for Holtec? No. Thank you. NRC staff, do you want to make a brief opening? You do not? Okay. Well, let me get back to the questions I tried to alert you to. Do you have a microphone, or are you getting one?
Your Honor, if it's okay, we were planning to do the same thing that Holtec did.
I'm sorry?
We were going to do the same thing that Holtec did and pass our.
Yeah, that's fine. Well, I have in front of me your filing on October 9, and I think we've asked you some of these questions yesterday or earlier today, but it would be helpful to run through one final time what the NRC staff's position now is on the admissibility of contentions. I think on October 9, I believe there were 6 contentions that you either thought were admissible in whole or in part, or at least you weren't opposing the admissibility of them. And let me run through them. I think NAC, now, and also the NAC contention you addressed, but in effect you said it was moot from your standpoint because you would not find NAC as having a standing. But nonetheless, you independently looked at the admissibility of its contentions, and NAC contention 3, I believe, relates to the adequacy of the analysis of alternative designs. And do you still think that that contention is at least potentially admissible?
We do, Your Honor.
You do? Okay. Then on, the 2 contentions are really very similar, at least in part. Beyond Nuclear's sole contention, and at least the first portion of Sierra Club contention 1, I believe you felt that those were admissible, again in part, the Sierra Club in part, and have, in view of the corrections as Mr. Silver has described them to the ER, or otherwise, have you changed your position on that?
It's not so much I would say that they've changed our position, Your Honor, but I think it may have been overtaken by events. Because with the revision to the ER, the portion of the contention that we had found admissible appears to be moot.
Okay.
But I know that I believe Beyond Nuclear is planning to then amend the contention.
I'm sorry.
I understood that they were going to then file an amendment based on that change to the ER.
Oh, they're
to the
good, okay.
contention. Which is what we talked.
So your position is if there's an inconsistency, it would be admissible, but at the moment you don't see an inconsistency and you would be changed. And your position is the same, but events have transpired.
Yes, our position on that contention is, other than the inconsistency, the petitioners have not identified how the issue they're raising is material to a finding that the NRC must make.
And your position on the lawfulness of what we've been calling option A or option 1, I believe you used the word premature to address that, but that apparently is no longer necessary to address. Am I wrong?
There's still an option contained in the application. Option, just some.
Correct.
But option 1 being that DOE would take title.
Correct. But counsel for Holtec International has represented, and correct me if I'm misrepresenting what you've represented, but has now represented that Holtec International's position is that at the present time, DOE could not, consistent with the Nuclear Waste Policy Act, take possession of the nuclear waste, except with an exception for a narrow exception, fairly narrow, for research materials.
Yes, I did hear them say that.
Okay.
That option is still contained in their application.
Right, we understand, but you were initially concerned, the staff was initially concerned about an apparent inconsistency between the language in the environmental report and in the rest of the application. And that appears to have been, we'll hear perhaps one last time from Beyond Nuclear, but that appears to have been cured for the present time. Is that correct? You're not disagreeing with that?
No, I believe that has been cured.
Let's move to Sierra Club Contention 4. And if I characterize you correctly, the staff thought that contention would be admissible in part. It would be admissible insofar as it dealt with the potential consequences of a nuclear accident in transportation, but not as to the likelihood of such an accident. And has your position changed at all on that?
Yeah, our position has not changed.
Not changed, okay. And I think there was only one more contention that the staff would have argued is at least admissible in part, and that was Sierra Club Contention 8, the decommissioning plan based upon an apparent inconsistency between the numbers, between how many metric tons of uranium would be multiplied by the amount that Holtec was proposing. And has your position changed on that?
Yes, Your Honor, we're no longer taking a position on that contention.
You're no longer, that's right, you said that earlier today, no longer a position. You're not opposing, but you're not taking a position.
We're not taking a position.
I'm sure you would have told me if this were the case, but the 40 or so other contentions, or total of 40 contentions, you haven't changed your position, the staff's position, on any other contentions as a result of the filings of the arguments today.
No. The Sierra Club and Beyond Nuclear both added a final contention regarding adopting one another's contentions. And I think that's, I don't know, it's not really a standalone contention. We don't have any objection based on our latest filing to the adoption if they each had contentions admitted.
Right. There was some filings about that. There were further motions about that. I think from the board standpoint, yes, the board has the power to tell them that one will be pursuing certain contentions and the other contentions. I think a major reason that a party would want to adopt another party's contentions is that one party may not be here for whatever reason. decides they don't have standing potential, or that they drop out. And I take it that in that situation, the NRC staff doesn't see any problem with someone who has previously adopted the contentions of the other participant or party pursuing those contentions to the extent they're, of course, admissible.
Correct.
Okay. All right. I think that is all I have. Judge Arnold, do you have a question for the staff?
Sure, a few. I've asked some of the petitioners here, and I'll ask you too. To your knowledge, does the Department of Energy currently hold title to spent fuel and greater than Class C waste?
Yes, Your Honor.
Is it a significant amount? Do you know about how much?
May I have a moment? Okay. Yeah, we would consider it a significant amount, both the Fort St. Grain and TMI.
So the condition in the application that they accept waste from the DOE would permit them to accept this waste that the DOE currently holds, correct?
Condition in the application.
In the application, they say they'll either take it from the DOE or from the individual plants. This Part 1, taking it from the DOE, would allow them to take the significant spent fuel and greater than Class C waste that currently DOE holds title to, correct?
Just one moment. Your Honor, neither of those are stored in UMax designs, so they're outside of this application, because this application will only allow them to take waste, or fuel that is stored in a UMax design.
Okay. Concerning Sierra Club contention to the issue of safer and more secure versus safe and secure, in order to grant a license, does the staff have to find that this facility is safer and more secure, or do you only need to know it's safe and secure?
First, we don't need to know that it's safer and more secure. No, I'll just go down.
This has to do with safe transportation of high-burn fuel, Sierra Club Contention 21. On page 71 of their petition, the Sierra Club references interim staff guidance ISG 11 for support for their assertion that the NRC staff is still working on the safety question concerning high-burn fuel amidst transportation. But this staff guidance is dated 2003. Do you know if this is the latest work from the NRC concerning high-burn fuel?
Your Honor, it's not the, well, it is the latest finalized guidance, I believe, on this subject. It was ISG 11 that was issued in the time frame that you mentioned. There was also a draft RIS that was published that I believe was referenced as part of that, as part of the high-star application. And there's a draft new reg 2224 that finalizes some of this guidance, but it's currently not in final form.
would you say the interim staff guidance is currently behind the state of the art?
Your Honor, I would not go that far. With respect to transportation, interim staff guidance 11 states that reviews that are done on a case-by-case basis at a time, and that's still the current state.
Thank you.
His answer, it's really hard to understand what he's saying.
Okay, yeah, I apologize.
Maybe slower, if you could talk slower.
We'll try to do that, okay?
I can repeat the answer. The question was whether interim staff guidance 11 was currently behind the state of the art, but interim staff guidance 11 states that it'll be evaluated on a case-by-case basis, and that is still currently how things are done.
That's according to ISG 11 or this draft movement?
Excuse me, ma'am.
I'm sorry.
No.
It's just hard to hear. He's still mumbling.
Maybe if you went for the, excuse me. Thank you for alerting us that you're having difficulty hearing, but the participants are only the ones who are here. Would you try the podium? Perhaps that would work better. Just repeat the answer.
Yes, so the question that was received was whether interim staff guidance 11 was behind the state of the art. Currently, interim staff guidance 11, the guidance that is in there states that it will be evaluated on a case-by-case basis, and that is still the method in which the NRC is doing these reviews.
Thank you.
So the answer is yes.
Question on joint petitioners contention 11. Let's see. Once again, this is about transportation of fuel and terrorism. And do you believe that transportation of spent fuel through the jurisdiction of the Ninth Circuit Court will require further environmental evaluation?
Your Honor, no. The facility itself is located outside the Ninth Circuit. Licensees are not a general license to ship fuel throughout the country under the provisions of the general license in Part 71 and approved COCs and approved packages.
Dr. Kuros, do you have further questions for the staff?
I do. In many cases, you heard the questions and answers that Holtec provided. So I just want to make sure you never identified any problem with those questions, with those answers. I'm going to assume that you're okay with and agree with them. Is that a fair assumption? Or should I ask questions over again?
Your Honor, Alana Weiss, if you're referring at least to the geological groundwater questions, the technical questions, we agree with Holtec's responses.
Okay, that's fine. I'll make that assumption, and I'll only ask you the questions that I want to hear you actually say yes to separately, all right? Let me start.
Sorry, I don't want to interrupt you. I just want to be clear. We don't agree with every word they said, in general.
All right, let's proceed. Let's proceed, and I'll try and get through as many of these as I can directly to you. All right, with respect to what happens if a canister doesn't pass the receipt and inspection criteria when it arrives at Holtec. Namely that namely that the canister's contaminated or damaged in some way, or doesn't, whatever the receipt and inspection requirements are, as provided in the SAR, it doesn't meet them. And I had asked the question, and the answer was that it would be shipped back to the Senate. And I'd asked the question, I believe, well, what would happen if, in fact, it was unable to meet the transportation requirements for shipment back to the center? And the answer was that it would be placed in a transportation canister that was available for that purpose, and would then be able to be shipped back. Do you have any problem with that?
No, Your Honor.
Would the NRC be notified if they received something that they could not store?
I'm not sure. It would depend on the details of the technical specifications, I believe, whether that would trigger a reporting requirement. I'm not familiar with the exact terms of that, but otherwise, there would also be, there's requirements before shipping that we have to approve routes. That may also trigger some sort of approval if they intend to ship a return that they hadn't expected to.
Okay, with respect to burn-up, and again, I apologize for having to repeat questions to you that I had already asked Holtec, but I have no other way of doing this. But I'm going to summarize. So the certificate of compliance requirements for fuel that can be shipped to Holtec was provided in Appendix B of the certificate of compliance, as I had said earlier. I referenced the table that provided burn-ups as high as 68.5 gigawatt days, I believe, and noted that the SAR analyses, or at least the SAR indicated number, was 45 gigawatt days. The answer came back that the analyses that were done did utilize 45, but there were other conservatisms in the analysis such that the results would be applicable to the certificate of compliance table requirements, including 68.5. Do you agree with that?
Your Honor, I can't speak to the exact details that were done as part of that application, but I would note that with respect to this application, as we stated in our brief, the safety and the review of the transportation package designs that we see is outside the scope of this hearing. I don't know with respect to the details of the SAR for the high star 190 system.
Okay, so you're saying that you don't know whether or not, you personally right now do not know if 68.5 gigawatt days can be accommodated in the facility safely. Safely meaning within the acceptability of the analyses that were done in support of the SAR. So.
I should clarify if that's the case, if that's okay. The high star, the COC represents what the staff found acceptable, and so long as something is transported in accordance with the appropriate COC or is stored within the UMAX system within that COC, if it permits storage of a high current fuel, then the staff sees that as sufficient.
Holtec said they took that all into account, and do you have any reason to think that's not correct?
No, Your Honor. And looking at the petitions, there's not a clear allegation of what the states that identifying exactly which portion is in scope that they're alleging a deficiency with, and also things that could potentially be in scope. It's unclear exactly what genuine dispute they have that they've raised.
Now, actually, I don't personally know if there are any fuel assemblies in the United States that are greater than 68.5, but clearly they would not be able to be shipped to the Holtec facility if they were. Is that a correct statement?
Your Honor, I think based on what is currently available, I believe that's correct, but regardless of whether something exists now or later, the issue of having a R71 license has already been issued under the general license. So if a package was approved in the future that could transport that, that could be transported, whether they could accept that at the site under their proposed license, they may ultimately require an amendment to accept it.
Okay. Yeah, and clearly all the paperwork says that it couldn't be shipped, and I have a nod from Holtec, so and you have no problem, so that's it. Holtec indicated that they haven't seen any cracks in canisters, and that the San Onofre experience no longer doesn't apply because of modifications that have been made. Do you agree with that?
Your Honor, I'm not familiar enough with the facts of what occurred at San Onofre to make a judgment on that here.
All right. With respect to contention 15, Sierra Club contention 15, this is the contention where, okay. I was going to summarize it for you, but that's okay. All right, well, I'll summarize it anyway. This is a contention that basically asserts that there's near-surface groundwater that was not identified in the environmental report. And also the next contention, I believe, Sierra Club contention 16, it's the same sort of thing, but with respect to the presence of brine in the shallow groundwater area. The staff answer basically was, we don't need to worry about that. It's inadmissible because there won't ever be a leak.
Your Honor, I would not characterize our response as such. It was rather that petitioners have a burden to controvert statements in the ER and the SAR. There were numerous statements in the ER and the SAR which established that there is no credible pathway for a leak from the facility, and we identified those. I can run through them if you'd like, but they're in the brief.
Okay, I agree with respect to the fact that there's no liquid release. So from that point of view, I understand that. But the contention was somewhat broader in the sense that it was trying to identify potential cracking mechanisms if groundwater were to get into in contact with the canister and that sort of thing. I had asked the question, if you ignore the transport of radioactivity part of those two contentions, and you just look at them as, is the ER adequate? Those contentions are claiming that the ER is not adequate. Just ending it right there. No more, no discussion of liquid pathways or anything. Do you agree with that? From that point of view, their contention is that the ER is not adequate. Do you agree with that?
Your Honor, staff is still reviewing the ER. As we discussed, there are RAIs ongoing. It's a normal course of business. So we do not yet have a position on the merits of the ER.
And I guess this this proceeding and the staff review came to a point of contact in another contention.
Let me just ask one question on this point. I believe the 10 CFR 51 requirement is for the applicant to describe the affected environment. If there's no leakage path, is any of the ground affected by this installation?
Your Honor, our argument could be made, but nonetheless, it's staff's position to describe the site characteristics generally to establish a baseline.
And we also discussed, and that's why I don't want to spend too much time going over things we discussed, but we also discussed that the aging management program in the SAR requires groundwater testing. And I can't imagine that they wouldn't use the ER as a basis for identifying what groundwater is there and what potential corrosive material might be in the groundwater. And therefore, having an ER that doesn't have the correct groundwater identified and the correct sources of, say, brine identified could be problematic from that point of view. I can't imagine in the aging management program they're going to go do some environmental analysis to try and find new groundwater. They're just going to use whatever knowledge they have of where groundwater is. I would assume that. And I had no basis for not assuming that based on the conversation we had on this yesterday. So, so from the point of, so you're telling me that you're not ready to answer that question?
We have not.
With respect to whether the contention, as it applies to just the adequacy of the ER, is...
Well, Your Honor, it's the petitioner's burden also to establish materiality, and our position is that because a credible pathway for the leaks has not been established, they've not shown the materiality of the contention, how it would affect conclusions in the ER.
Yeah, well, contention 16 was, with the brine discussion, was really talking about brine affecting the facility. Contention 15 with respect to the presence of groundwater was identifying that as a pathway to the environment if there's a leak. So, you know, they're not exactly, but both of them have the one thing in common, that they're claiming that the environmental report is not adequate.
That is correct, with that is their claim.
Okay. All right, let's see. I'll ask this one again. There's a claim that a crack in the canister or in the UMAX cask enclosure is not credible, and that there has been no experience of cracking the canisters. I don't know if we just covered this, I don't remember, but could you just, do you agree with that?
Could I confer with staff for a second?
Yeah.
Your Honor, that's correct. There is no evidence of any NRC licensed canisters cracking.
Okay, so with respect to subsidence the possibility of subsidence in the site vicinity, you heard the answer that Holtec gave, but I'm going to ask that one again. Do you agree that there is no possibility of subsidence at the Holtec site?
Your Honor, we are conducting our review currently of the potential for subsidence at the site. I would point out, you mentioned the ER, and I believe your citation was to the possibility of regional subsidence. I'd like to provide you with citations to ER 4-5, as well as ER 3-14, at which point they both noted, the ER notes that there's no evidence of local subsidence actually at the site as opposed to in the area.
Right, and that is consistent with what Holtec is
correct.
Told us.
Correct. I'd also, if I could, Your Honor, the SMU study that was referenced yesterday for evidence of subsidence, I believe it's in footnote 26 of the petition. The closest subsidence that the study references is approximately 75 miles from the site.
Okay. And by the way, this is Don't Waste Michigan Contention 12, I believe. So, and
I was referencing,
and also 5.
Yeah, that was my response referenced footnote 26 of Contention 5.
Okay. So, yeah, so 5 and 12 are really, they're, as we said yesterday, one is, they're the same, they're dealing with the same thing, but one is human activity and the other is geologic activity. So one natural, one human.
If I could point out with respect to Don't Waste Michigan Contention 12, our position is that contention is not admissible as the petition did not reference the SAR or the ER.
I understand.
Okay,
I understand.
thank you.
Okay. With respect to hydraulic fracturing below 5,000 feet, does the staff agree that that totally precludes the possibility of subsidence effects?
Staff's review is still ongoing on that as well.
Okay. But you heard the answers that were provided that in a positive way, that if you drill below, and I think they said 3,000 feet, but certainly if you drill below 5,000 feet or hydraulic fracture below 5,000 feet, there will not be a subsidence effect.
Yes, and Your Honor, staff has not yet made a conclusion on that.
So you're still working on that?
Correct.
Okay. And with respect to this issue that came up, your answer to contention 23, if you're worrying about defects that might occur during the service life, 100-year service life, well, I guess your answer did not address the time period up to the service life. I think you were addressing the license life. And we discussed yesterday that any extension beyond the license life at each stage would be required to be reviewed as a license renewal, which would include an environmental review and a safety review. So one could not get to the even the design life without having to go through a series of reviews. Is that correct?
Yes, Your Honor.
So we don't need to worry about 100 years right this minute, and that's consistent with the guidance as well.
Yes, Your Honor, based on cancers that could go in the facility as proposed, and the 4-year license term, there'd be no way to reach 100 years without another renewal.
I pointed out earlier again that a cursory look at the Schaffersman report, it seemed to me was in direct dispute, if you will, with part of the ER, specifically section 3.3.3 of the ER. And section 2 of the Schaffersman report with respect to karst geology formations. Do you have any comment on the adequacy of section 3.3.3 of the ER?
1 minute, Your Honor.
Thank you.
As a preliminary matter, Your Honor, if I could note, the Schaffersman report is only relied on for contention 12. It's not mentioned as a basis for contention 5.
And Holtec had an elaborate answer to this as well, so, but I'm asking you separately.
We're not going to take a position on that at this time as our review is still ongoing.
I had asked the question, would subsidence on the site potentially cause damage to the UMAC system? Do you have an answer to that?
No, Your Honor. May I confer with staff?
Yeah.
Your Honor, that is an area that is under review currently, so we are not taking a position.
Okay. All right. That is my last question. I've had, all my other questions have been answered throughout the proceedings, so thank you very much.
All right. Well, we're now either virtually done or almost done. We did suggest the possibility in our order that if there's an interest in them, we could have very brief final statements from the various participants. Or perhaps I could just take ask for a show of hands. There is interest.
Voting flag.
Voting. Well, what we'll do then, we'll take another break, and we'll go through in the same order. If any, do not feel you need to say anything. If you don't want to, do not feel you need to use all 5 minutes. We will limit these to 5 minutes maximum, and we'll go through in the order. I think we'll try to restrain ourselves from any questions. but we will provide that opportunity. One thing I will mention too, I am sorry if there was some problem with the audio. It sounded like it's now working, or at least when the podium is used. But I should alert people, if you really have an interest, there will be a written transcript of this proceeding, which is being prepared. I'm not sure exactly when we get that, possibly 3 working days or something like that. And that will fairly promptly be posted on the NRC website. So if you go to the NRC public website and you go to the electronic hearing docket and find this case, it will be there in its entirety within a reasonable period of time. I'm not sure exactly how long.
Is that nrc.gov?
Correct. Correct. And there is a public, the staff may know better than I, but there is a public access to the electronic hearing docket that virtually all the documents are available on. Pardon me?
I'm happy to turn the mic off. I'm happy to show any member of the public, if they have internet access, how to get to the electronic.
Great. Well, they may come and see you on the break. Thank you very much. All right, let's resume at 20 of 3, 2:40. All right, so what we're going to do, as we said earlier, we're going to have very brief final statements from those who wish to make them. No more than 5 minutes. You do not have to make one. You do not have to take 5 minutes. But we will begin with Ms. Kirk.
Thank you.
For Beyond Review.
Yes. At the end of these 2 days, it is safe to say that everyone agrees that DOE cannot currently take title to privately owned spent fuel, except in a few narrow exceptions. And everyone agrees that the purpose of the Holtec project is to take spent fuel from privately owned nuclear reactor sites. I would like to respond to 2 statements by Mr. Silber to the effect that this doesn't matter. First, Mr. Silberg said that having an option that DOE may take title to spent fuel, which we've been calling option 1, that may currently violate the law is okay because that option could be severable. He referred to severability clauses in contracts that can save contracts from such illegal options. But severability clauses work by allowing for the illegal provisions to be struck from the contract. If Holtec is willing to strike the illegal provisions from its application, removing option 1, and then refile the application, this could, of course, negate our legal claims. In the meantime, we continue to maintain that an application that would allow for DOE ownership of spent fuel, whether it is characterized as alternative or contingent, is unlawful under the Nuclear Waste Policy Act and the Administrative Procedure Act. In fact, what Holtec is asking the NRC to do is the very type of action the APA prohibits. As the district court held in State of New York et al. Versus U.S. Department of Commerce, and those numbers of the docket, it's still a slip opinion, are 18-CV-2921 and 18-CV-5025, January 15th, 2019, agencies are not above the law, and they cannot do more than Congress allows. As the court recognized in the State of New York, the APA is meant to protect the integrity of legal proceedings like this one. As the court explained, and I just want to read this to you because I think it's very eloquent language. Although some may deride its requirements as red tape, the APA exists to protect core constitutional and democratic values. It ensures that agencies exercise only the authority that Congress has given them, that they exercise that authority reasonably, and that they follow applicable procedures. In short, it ensures that agencies remain accountable to the public they serve. Here, by even entertaining Holtec's license application, the NRC has shown a serious lack of accountability to the public, not to mention a lack of consistency with its own standards. As Judge Ryerson noted earlier, any member of the public taking issue with a license application that's been filed with the NRC has an ironclad obligation to contest the application with specificity and support. License applications are thus treated as real and serious and not hypothetical. Here, as is demonstrated by 2 days of oral argument, petitioners have spent precious time and treasure analyzing an application that is fundamentally hypothetical. We are not just chasing a rabbit that may disappear down the hole, we're chasing the white rabbit, a fictional creature. Second, I want to respond to Mr. Silberg's suggestion that it doesn't really matter whether the owner of the spent fuel at the Holtec facility turns out to be the DOE or a private licensee, because the impact analysis of the environmental report would not change if DOE were the owner of the spent fuel. Setting aside the illegality of Holtec's license application under the APA, Mr. Silberg is wrong as a practical matter. If DOE becomes the owner of spent fuel to be transported from reactors to the Holtec facility and stored there, that would need to be done by federal legislation. As Mr. Silberg said in his opening statement, the issue of what to do with spent reactor fuel is a huge national problem. Congress effectively would be crafting a temporary alternative to the national repository. In that event, it is very reasonable to assume that Congress would put DOE in charge of such a national project and not Holtec. And as the driver of the project, DOE would likely be responsible for the environmental analysis. It is not hard to imagine that the range of alternatives examined in a DOE-prepared draft EIS for a national spent fuel storage program would include more than one type of cask and more than one type of facility design. In all likelihood, Holtec's proposal would become an alternative for DOE to consider in its own EIS, not necessarily the proposed alternative. This is a huge difference. As Mr. Silberg stated today, the purpose of this project is to deploy Holtec casks, not NAC casks. The purpose of a national spent fuel storage program would be to solve the national spent fuel storage problem, not to advance one company's spent fuel management business in preference to another's. Under the APA, the NRC may not continue to entertain an application that could require federal participation in the ownership of the spent fuel to be stored. Holtec's application should be dismissed, and Holtec can refile after the Congress has taken the necessary action. In the alternative, if Holtec wishes to continue to pursue this license application now, it must drop from the application any reference to the DOE as a potential owner of the spent fuel. Thank you very much.
Thank you, Ms. Carter. Next, we have, I believe, Mr. Taylor for the Sierra Club.
Thank you. As the board reviews the admissibility of the contentions, I ask that you keep in mind the standards for admissibility of contentions. At this point, we are not required to prove our case. In fact, the burden of proof is almost on the applicant. We have tried to draft our contentions narrowly and specifically so they are focused on definite facts and issues. The Commission has said that a petitioner needs to only come forward with factual issues, not merely conclusory statements and vague allegations, as cited in Northeast Nuclear Energy Company at 53 NRC 22. In other words, the contention should make enough of a showing to require reasonable minds to inquire further, as said in Vermont Yankee versus NRDC, the U.S. Supreme Court case at 435 U.S. 519. We have tried to comply with those admissibility standards. I suggest that Holtec, and to a lesser extent the NRC staff, are attempting to impose an improperly high standard on contention admissibility. They are claiming that Sierra Club must set forth in great detail the facts, often very technical in nature, and with pinpoint specificity, argue exactly where the Holtec documentation is in error or inadequate. As I explained a moment ago, that is not the standard. Furthermore, it seems as if Holtec can make unsupported conclusory statements in its documentation, and then it's up to a petitioner to refute those statements with detailed facts supported by expert testimony or irrefutable authority. That improperly shifts the burden of proof. In fact, as we saw here today, I would suggest that Holtec was basically allowed to orally amend its application documents by responding to the board's questions. With respect to a few of the issues, as Ms. Curran suggested, the idea that DOT would take title, as we now see Holtec admitting, is a purely hypothetical, and a license cannot or should not be issued on the basis of a hypothetical. If in the alternative, we go with option 2, as you described it, with the private reactor owners retaining title, there's absolutely nothing in the Holtec documentation that would infer at all that the plant owners would want to retain title. So again, it's hypothetical. With respect to the service life of the containers, the safety of the containers on into the future, the aging management plan that Holtec is relying on, although it may be a requirement of the license, there's absolutely no assurance beyond that license period that the AMP will be carried out. It is purely voluntary from that perspective, and there's no oversight. Holtec imagines that they'll keep getting license extensions apparently, but in their documentation they've only expressed the intent to get the initial license and perhaps a 40-year extension. That's only 60 years. So they have not shown any indication as to what assurance we have of the safety of the containers beyond that 60-year period.
I think we're going to have to ask you to wrap up.
Okay,
next
thank
minute.
you. Okay, thank you. I didn't realize I'd gone that long already. We would ask that the board find that Sierra Club has standing and that our contentions are admissible. Thank you.
Thank you, Mr. Taylor. Do we have anyone here today for Alliance for Environmental Strategies? Is Ms. Simmons here?
Ms. Simmons is not here.
Is not here. Well, again, it is not necessary to make this final statement, so the Alliance petition stands on the record that we have.
As a member of AFES, could I speak briefly?
Actually, it's clear in our order that today we're only hearing from people who have filed appearances with the NRC. But we heard from Ms. Simmons yesterday and we had her meeting, so thank you very much. Next, we have Mr. Lodge for joint petitioners.
Thank you very much. And thank you for the board's presence and the attention and rigor and preparation that clearly has been reflected in the last couple of days on your part. There's a number of points I want to make. I was very troubled this morning by the Holtec statement that remediation concerns are outside the scope of the proposal. And I think it's a little bit difficult for that point of view to be sustained given the revelation in the last approximately 10 days of November RAI responses from Holtec that indicate a slight change in the return to center policy, whereby Holtec now says that if there are non-conforming casks with contamination, leakage, whatever, they will either be returned to the originating reactor site or diverted to a facility with loading capability. Loading capability, of course, being code for some type of dry transfer system or some type of means of being able to unload fuel or otherwise work with very dangerously radioactive casks. So remediation is quite within the scope, and in fact, remediation and the apparent indifference on the part of Holtec to the need to have the capability then and there on site is a major issue and is within the scope. Some of the realities that are being avoided with magical thinking include the NRC staff's admission some months ago that 29 storage canisters at San Onofre are damaged. So we start out with the potential, and I, of course, cannot guarantee that Holtec will be taking those canisters, but in the event that they do, we start out with known knowns that there already are, in effect, damaged canisters that are going to be coming, and they're going to have to be dealt with in some way. There will have to be reality-based thinking in the acceptance plan. One of the points that my petitioners were attempting to make through Dr. Ballard's report and remonstrance was precisely that there's a mission creep potential here. That Holtec could become a de facto permanent, not repository, but a permanent place where all of this garbage stays essentially forever. Part of the psychology that I fear and suggest may come to pass if this plan is somehow approved is that Holtec will also become the destination for a lot more waste than simply commercial nuclear reactor waste. There's still defense, there's military waste out there. As we have heard and discussed, there's DOE waste that was taken off the hands of commercial operators. And one of the reactors that hasn't been mentioned that we believe DOE probably has possession of their waste is Fermi 1, which was, of course, a fast breeder reactor which generated during its thankfully limited lifetime a great deal of plutonium-laden radioactive waste. So just to designate and limit and see formal limitations that are binding on the part of Holtec would be a welcome and necessary event. Another point I would like to make is that to get back into the 173,600 ton Merc is footnote 137 in the answer that was filed, I hope I can find it in time. Footnote 137, basically, I'll summarize it. In the Holtec answer to the Don't Waste Michigan petitioner's initial petition, states essentially that 173,000, the 173.6 figure, may be what they call an overstatement of the likely waste to be delivered, but they essentially admit that it creates, or that they have taken some liberty to overestimate because there is probably going to be more than 100,000 tons of waste. So today, we still don't know. It's an unknown knowable. Finally, I'd like to talk about standing. The calculations that were performed using the US EPA's online environmental justice population demographic tool suggests that the known rail routes, the mainline routes across Texas that are very, very likely to be used at some point for delivery to Holtec, that within 800 meters on either side of those railroad lines, in the aggregate, 2010 data, census data, suggests that approximately 930,000 Texans live within a half mile of a rail line where literally hundreds, if not thousands, of loads of cargoes will be delivered. In New Mexico, The figure is approximately 132,000 people live within a half mile either side of the likely rail delivery routes. That is the equivalent in New Mexico of, pardon me.
We're going to have to ask you to wrap up in a minute.
I'm getting there. Thank you, sir. It is the equivalent of twice the 2010 population of Santa Fe living within a half mile. It's 132,000 is more than the combined populations of Hobbs, Carlsbad, and Roswell combined, and it's greater than the population of Las Cruces and Hobbs combined. Standing has been established. It's been established by our declarations. And it is a bogus argument against standing that somehow the rail routes are unknown. My final point is this. Regarding mostly the rail routes, since that's approximately 95% of the delivery, I keep seeing this suggestion that the rail routes will be chosen by the Federal Railway Administration. They're out of our hands. They cannot be known. It's years away, et cetera, et cetera. That's false. If there's another federal agency that may or indeed must be included in consultation for NEPA, then let's bring them in with the NRC acting as the lead NEPA preparer. But you don't just say, we can't do anything, it's another agency, it's another turf, we can't talk about it. There are environmental justice concerns, there are very distinct standing, there's considerable evidence of standing. And that raises the other final problem, which is that we are, as interveners, required to have our contentions projected out 120 years. We are required, and more than 30,000 comments in opposition to this plan are essentially calling upon the NRC to consider the largest maximal picture possible. That's what NEPA requires. That is the obligation and the charge on the Commission. Thank you very much.
Thank you, Mr. Locke. Mr. Desai for NAC International.
Thank you very much for having us here this week. I'll start the closing, and then the General Counsel of NAC International, Mr. Holtec, will finish. There'll be time to give a stop. I will start with the environmental issues, as you expected. But I'm just going to repeat a few lines of New Reg 1748, which is referenced to the NEPA standard in Section 1.0 of the ER and discussed throughout. Section 5.25 is core. It states that failure to address an alternative, and in order to fail to address an alternative, you have to have a brief discussion of the reasons for rejecting the alternative. Holtec provides a reason that is incorrect and now been disavowed. It's universal system, failing NEPA requirements. The NRC staff agrees with us here. Section 5.2.4 states, reasonable alternatives include those that are practical or feasible from the technical and economic standpoint and using common sense, rather than simply desirable from the applicant's point of view. We discussed a lot this week on reasonable alternatives, including the open alternative being built down the road. Keep in mind when reading Holtec statements about alternatives and the last few comments of our exchange about alternatives and competition. Now, as the time, the whole facility is getting its NEPA review here, all 20 phases. The amendment that is always being advocated as this cure-all is for cask use. Look at the cases. We can't relitigate facility design later on. Think of it this way. If a power plant gets a license for another fuel type, it can't at that time relitigate the alternatives to building the power plant. And they say their amendment may come sooner or later. That's the point. They can do it whenever, including after the facility is built. Recall, a facility can't get built under NEPA unless the NEPA review is done. They're getting that facility level review here so they can build the facility. And then we can't litigate a NEPA issue on a facility design after it's been NEPA approved and built. So when Holtec takes the position that we have participation, please take a hard look to make sure we actually have hearing rights. And those hearing rights are the same as we would get now. Thank you very much.
Thank you. Welcome. sir. I think I recall seeing that you have entered interference.
Yes, I have. Thank you, Your Honors. Thank you all. I'm Bob Helfrich, NAC Senior Vice President and General Counsel. As we said yesterday, with respect, NAC is not opposed to a consolidated interim storage facility in principle, including this CISF. We narrowed our contentions out of consideration for that. Please assume for a moment that universal is not just a term that relates to size, like a diameter or a volume of a UMAX underground receptacle. But is there any so-called universal cask, such as described in the UMAX CFC Amendment 3 and in the environmental report, which is feasible for NRC approval under Part 72 today, and where the applicant does not have access to the original proprietary design of the vendor, who is the CFC holder of the canister? We had noticed the difficulty in the UMAX CFC Amendment 3 docket, where the NRC questioned Holtec's lack of original proprietary design information to address standard functions such as criticality, shielding, thermal design, cooling, and structural integrity. But that is just the licensing aspect of the term universal, which is Holtec's term, used in the environmental report, for example, at section 2.2.2.1, stating UMAX is the only licensed technology with the universal capability, etc. The phrase was not universal capacity. But either way, it's not yet licensed. This is an assertion by Holtec, an assumption that is an essential element of this application, as explained in the NAC's George Carver's affidavit with our petition. Without the original design information for the other non-Holtec canisters available, how will Holtec, as the ISPC licensee and owner, respond, diagnose, safely manage, and correct for an incident or an operational event? Something involving mishandling, for example, where realistic and accurate calculations, not just bounding, are needed. NAC wants to know, is a Holtec UMAX universal cask feasible for NRC approval for this facility? If it is, we need to be involved now. As a final point, NAC respectfully suggests, as a first step, if Holtec does not want to address any non-Holtec canisters in this application, then perhaps Holtec would eliminate the term universal in the application as it refers to the UMAX cask and limit the application to only Holtec canisters for which licensing approvals exists. The use of the term universal, with all respect, is causing confusion. Thank you.
Yes, sir. Let's see. We next move to Faskin, Mr. I.
Thank you, Mr. Chairman. A few brief comments to close. To the extent that the license application continues to use the either or in terms of the alternatives as to who would have title or the right to take title, that raises a hypothetical that we think is improperly considered in the context of this license application. And I support that with asking the panel to consider how far a petitioner's contention would get, raising a hypothetical and asking the board to consider it. Likewise, Holtec infers, suggests, implies, states flat out that there's a legislative fix for this. That is pure conjecture and speculation. Nobody knows what kind of bill might come out of a committee, what its marked up version would be, what amendments get offered and adopted on the floor, whether it would be signed by the president. That's complete conjecture and speculation. And I would suggest again, that approach by a petitioner would be unsuitable and rejected by licensing boards of the NRC. Hence, if there's going to be essentially more or less fair treatment of the parties, Holtec should not be allowed to engage in speculation, conjecture, to support its license application. Finally, there was a suggestion this morning by Mr. Silberg that while there's his suggestion is that this facility is safer than counterparts in urban areas because it's in a sparsely populated zone. That conflates safety with potential for the number of injuries or harm, the kind of harm that might result. If, in fact, these facilities are as safe as Holtec suggests, they could be put anywhere. They could be put in Westchester County if they're that safe. But that's not what's being proposed here. Instead, the burden of the harm is shifted to an area that's sparsely populated just because it's sparsely populated. No other quality would support that. That is not a fair way to evaluate whether this facility is safe. So, with those comments, I would thank the panel for its attention.
Thank you, Mr. Rock. Holtec International. Mr. Silberg.
Thank you, Mr. Chairman. I hope you give me a little leeway because I'm responding to
5.5 to 1.
5.5 to 1. First, and I wasn't planning to give a closing statement, but since everyone is, I think it's appropriate. We're pleased that the board and the audience here were able to listen to the strong local support from the folks from Eddy County and Aaliyah yesterday and today from Carlsbad. It's unfortunate that yesterday's presentations for people who were listening remotely, when the audio link went out while they were speaking, and we hope that their presentations will be clearly on the record so that it will be the strong local support that we have will be reflected. Let me try to go through some of the comments that we just heard. The issue of the DOE presentation is that is it hypothetical that DOE will participate? We don't know. There was legislation on the floor of Congress to do that. That legislation did not pass. Mr. I said, all this is hypothetical. On the other hand, Mr. Lodge said, we ought to assume that there's going to be federal legislation. We ought to further assume that that federal legislation will result in taking the site from private ownership. We should further assume that that federal legislation will force other casks besides Holtec on that site. When we talk about hypothetical and speculative, that's about as much as I've ever heard. We need to show a basis. Sierra Club's counsel said that they shouldn't be required to prove their case. That's correct, they should not. But their obligation is to show that there's a basis for their contentions that is material to the contention. We don't expect a determination of whether those bases are factually correct or better science and technology than ones we might have, but we do urge the board to take a look at those documents to see whether they meet the test of materiality. You don't require detailed facts. You don't require a refutable authority, and we're not urging that on the board. But we do need to make sure that the Commission's rules on contention and disability are adhered to. And we hope you'll take a hard look at the filings of both sides. In terms of DOE's taking title, it's clear that from an environmental standpoint, DOE's presence as an option has no impact on the environment. Whether we identify it as an option down the road certainly doesn't make the application illegal in any sense. We recognize that the current State of Nuclear Waste Policy Act does not permit, except with respect to spent fuel that's already owned by DOE, does not require that they be a party to this. On the other hand, if in the future they should become a party to that, it is an obvious fact, but it does not change any of the environmental consequences. There's a question raised about the role of the AMP beyond the licensing period, and that that's voluntary. I think we had testimony clearly that it is not voluntary. And beyond the license period for that part of the license application, or any part of the license application, is clearly set aside by the continued storage rule. I still don't understand the continued reference to the 173,000 tons. That's been fully explained. I also don't think it's terribly relevant to this board's rulings. I don't think it provides a basis, because I don't think there is a basis for that number. In terms of the railroads, whether or not there are 900,000 or 132,000 people on a half mile on either side of railroads, and whether that's an environmental justice issue, I do note that the Consolidated petitioners, Don't Waste Michigan and others, have not raised environmental justice contention. So I don't think it's appropriate for them to raise that in their closing statements. With respect to the NAC statements, I would note that they are incorrect in saying that there are no cases in which one vendor's cask is stored in one vendor's canister is stored in another vendor's cask. In fact, at this very time, at the Trojan plant, there are Holtec canisters that are stored in TransStore casks. It is something that happens. It's not a violation of law. It's not inappropriate, and it certainly doesn't create additional environmental consequences. The issue that we ought to consider NAC canisters on our site violates the very basis of our purpose and need statement. The purpose of this facility is to deploy the Holtec UMAX system. It is not to bring other people's casks on the site. We don't need to do that. We've explained why that is not required as part of the design alternatives consideration. We're not surprised, and we're glad to hear that NAC is not opposed to this facility. They are apparently opposed to the word universal. In the context of an environmental report and talking about phases that are not before this board for the license, we think that that concern is not relevant basis for a contention. If the NRC should license the storage of NAC canisters in the Holtec UMAX, then it will be appropriate. If the NRC is able to do that without access to NAC's proprietary information, we believe that they will be able to do so, then storage should be perfectly fine. If NAC is unable to license that system, without the access to NAC proprietary information. And if that proprietary information does not become available, then the NAC canisters will not be stored on the Holtec site, and their concerns are moot. In any event, we don't need access. We don't believe we need access to proprietary information. And if we do, and we can't get it, their concern is moot. With respect to the legislative fix, as Mr. I said, being purely hypothetical, we don't know what will happen in Congress. We don't know a lot of what will happen tomorrow. However, if it does happen, it's perfectly appropriate for a document which is intended to look out to the future to say this might happen. In this case, if it does happen, it doesn't affect the environmental consequences of this action. And therefore, even if it does happen, we think the presence of option 1 in the environmental report is of no materiality, and therefore not the basis for the contention. We really appreciate the board's clearly intense scrutiny of the application documents. We were pleased to be able to provide answers to the extent we can. We think we did. And we look forward to the next phase of this proceeding. Thank you very much.
Thank you, Mr. Silver. Does the NRC staff want to say anything? That's what I guessed. All right. Well, thank you all. That concludes what we intended to cover at this proceeding. Now, our job now is to take all the information we've received, and that includes the hundreds of pages of pleadings that I referred to yesterday, and everything that we've heard today, and render a decision on the standing of the various participants, the petitioners, and on the admissibility of their individual contentions, to which there are approximately 40, I believe. It's our intention to rule at the same time on the local government petitions, which again stand unopposed, and all pending motions, of which I described the first day. We have all sorts of pending motions that are related to those major issues. The NRC has certain milestones for us, which we always try to comply with. Basically, we should try to render a decision within 45 days of the argument or 45 days of the last pleadings that were filed. This has gotten a little complicated here because last week there were, I believe, 2 sets of motions for new or amended contentions, and the briefing on those will not be completed until well past the middle of February. So just considering those, it looks like our timing, which would have been around March 11, I think, will probably push back to early April or so. There's a little further complication in that there may be further filings. And at some point, I think we have to make a decision that we're going to decide based on the briefing that has been completed, and that we will defer to the second decision, additional motions. I think the motions we received last week are sufficiently closely related to the Sierra Club's contention and contention 1 and to the beyond nuclear contention that it really doesn't make much sense to try to sever those in any way. I think they're part of the same types of arguments, and so we will deal with those together. We'll have to see the filings that may be coming in the next couple weeks, whether we really have to sever those or just push the whole decision back a little bit. So that's where we are. Most likely a decision on everything in very late March or early April, but possibly even later than that. If we can't meet the milestones for any reason, we will issue a notice to that effect. Let's see. Now, on behalf of the board, I want to personally thank all of the council who've spoken today, and as well as the representatives of the local governments. I think everybody's been extremely professional, and this has been extremely helpful to us as we make our decisions. Also, as most of you know, this forum, the Bar of the State of New Mexico, was a place we had to come to on relatively short notice. We were all set up to use the federal court, the older federal court building, the historic one, and apparently there's some funding problems in the federal government at the moment, and they were unable to assure us at some point that they could support us. So we made a relatively sudden decision to come here to the Bar of the State of New Mexico, and the staff here could not have been more cooperative and helpful. This has been wonderful for us, a wonderful opportunity to make a quick shift and have what I hope has been, from all standpoints, a successful two-day event. So do I have any comments from other judges? Judge Arnold? Judge DeGrosse?
I think you said it. Thank you.
We have one. Mr. Lodge is standing up. Mr. Lodge.
Your Honor, I wonder if I may make a very brief request of the panel.
You may make the request.
Thank you. All right, to start. We request, on behalf of the joint petitioners, a 14-day period for the board to hold open the record of this proceeding for the purpose of our providing some documentation related to the Baltimore tunnel fire policy that was discussed this morning. We would like to respond to the issue of whether or not there were maps and the implications.
All right. Well, let me say this. We're certainly not going to decide anything in 14 days. Indeed, the new contentions that go beyond that for the briefing. Whether what you submit is something that we can appropriately consider is another issue. But you may submit something within 14 days.
Thank you very much.
Fair enough. Fair enough. Again, no assurances that we will consider that is something that was required or permissible or appropriate in view of what's been said here. But no, we're not doing anything for the next 14 days. We're working, I hope, for the next 14 days. We're not issuing any decisions. All right. We stand adjourned. Thank you again.